called to order at 6 p.m. If everyone would please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. This Board of Education work session is a meeting of the Board of Education in public for the purpose of conducting the school district's business and is not a public community meeting. However, there is a time for public participation during the meeting. General public comment will be heard under Agenda Item 7.1. If you wish to speak tonight and have not already filled out a yellow card, they're located on the table behind you. Once you've completed the card, please hand it to a Safe Ed officer in a yellow shirt. Please note that the cards must be completed prior to speaking. I'll call the names of those who I have a card for during public comment. When addressing the board, you'll have 3 minutes to speak. We'll let you know, well, actually you'll see it on this back section and I can't see it, so just pay attention to that time limit. When addressing the board, state your name and your relationship to the district. Please address your comments to the entire board and not to individual board members, school district employees, or to members of the audience. The board will not be responding to comments or questions during the meeting. However, someone will follow up if needed. We also reserve the right to exclude from our meeting an individual who engages in conduct that constitutes a breach of the peace. To my board colleagues, I'd like to remind everyone to please be respectful of each other and our administrators. Specific language can be found under Board Bylaws 0139.5 and 0139.6. On behalf of my colleagues on the board, we are grateful to be able to serve this community and appreciate your support. For roll call, all board members are present. Moving on to the approval of the agenda, is there a motion to approve the agenda as presented? Moved by Trustee Annis. Is there support? By Trustee Blake. Is there any discussion on this? All of those in favor, please say aye.
Aye.
Aye. Opposed? That's a 7-0 vote, and the agenda is approved. Moving on to Agenda Item 4, this is where we reference various communications that have been received. Item 4.1 is communication received by the board. Secretary Gupta, would you please give us an update?
Sure. At this time, the board has received 6 communications since the last meeting. They're in the packet for reference. We've also received a direct email to the full board from Dennis Toludo regarding cybersecurity and direct mail from a community member regarding secularism.
Thank you. Item 4.2 is citizens requesting placement on the agenda. Gary Chai has requested placement on our agenda this evening. If anyone is interested in requesting placement in the future, there is a form under the Board of Education on our website. Those requests are due by noon, 3 business days prior to our meeting, which would be Wednesday for a Monday night meeting. Mr. Chai, if you would please come forward.
Sorry, I'm not that tall. Okay. Hi, my name is Gary Chai, and I'd like to speak to the topic of DEI, which was discussed in this location 2 weeks ago. Maybe just to add some perspective and some background to my statements later, I'd like to give a background of myself. So I was born here in Pontiac and went to Meadowbrook Elementary until I was 9. Where without too much choice of my own, I was, with my parents, left Michigan to go to Singapore. Singapore is a small island city-state in Southeast Asia where people of multiple cultural backgrounds are celebrated. And then when I was about 18, I left Singapore to Adelaide, Australia, where I received my bachelor's degree and my PhD in mechanical engineering. Australia, being situated quite near to Southeast Asia, also has a lot of diverse people mingling around, so it is also culturally quite diverse. There's also a tenet in Australian culture where everybody deserves a fair go, which means that, you know, regardless of your background, of your culture, your religion, or whatever. Everybody deserves a chance to succeed in life. So after receiving my PhD award, I found myself quite luckily, with also some good timing, an opportunity to get a senior engineer role here at Chrysler, and that was back in 2016 when I was 27 years old. So having recalled very good memories of growing up in the Rochester area, we decided, my wife and I, to buy a house and settle down in Rochester. So it is with that kind of context, so I like to address the DEI topics from 2 weeks ago. I was quite disappointed to hear some of the statements, and it is also distressing to hear, and I quote, return on investment on the terms used for DEI. I think it's, I mean, how do you measure like a monetary value on community spirit? Or how do you measure the monetary value on self-esteem or a child's anxiety, or things like, just basic mutual respect? So I understand it's in the board's purview to, to manage the monetary expenditure, but I think we need to, consider that DEI also includes the words equity and inclusion, which, the word equity is referred to in the Declaration of Independence, where, all men are created equal. So that's my comments for today. Yeah. Thank you.
Thank you. All right, agenda item 4.3 is the section where members of the Board of Education share communications that were sent directly to them and were not sent to the full board. Did any board member receive communication from the public? Trustee Blake?
I received a large, actually, stack of communications from the following people at Delta Kelly. The information literacy specialist, the learning consultant, these were separate communications. Resource room teacher, every third grade teacher, every fourth grade teacher, thanking me for supporting teachers and students and being in their corner, and I appreciated those.
Trustee Gupta?
I received a direct communication from Derek Monroe regarding shared time instruction, and also from Mark Lipovsky regarding Lego League robotics at Hugger Elementary.
Thank you. And Trustee Annis?
I received communication from Julie Stalker regarding the policy changes that we'll be discussing tonight.
All right, and Trustee Blake, you reminded me, I did receive a number of note cards as well from Delta Kelly, but I did not bring that list with me, so I think, and Trustee Annis as well, so we thank those at Delta Kelly who sent those. All right, any others? Okay, we are moving on now to agenda item 5, which of our work session. There is only one topic today, which is a review of our policy revisions. I'm sure that there will be much discussion, but I want to ask the board colleagues to please keep their comments focused on the proposed policies so we can try and get through them. We also may reach a point where we need to identify who is okay with something and who isn't, and move on from there if we can't come to a consensus. At this point, I would like to turn it over to Kevin Sutton from Miller Johnson, who has been working on these along with our Superintendent's Policy and Curriculum Committee. Mr. Sutton?
Thank you, Madam President. Good evening, everybody. Kevin Sutton from Miller Johnson. First order of business is to introduce the gentleman to my right. He will be familiar to the Policy Committee because he joined us at least one of our committee meetings, but this is Adam Blaylock from Miller Johnson from our office in Detroit. Adam has joined me this evening to serve a couple of roles. One is to make sure that we're scribing all of the feedback that the board has to give and make sure that we're accurately recording that so we can make updates as appropriate and as needed. And secondarily, and I think even more importantly, Adam brings a wealth of experience, and I shared this with the Policy Committee during our process. Not only is he an incredibly accomplished attorney who's worked in the education sector his entire practice, he was not that long ago a sitting HR director in a Metro Detroit school district, and so has seen practical application of policy, these policies, in particular. And so I asked him to join us this evening so he can lend his expertise and his insights as appropriate as we dialogue through this process. I apologize in advance. You can probably tell from my voice I'm getting over it a little bit here and still not feeling 100%. But given the tremendous amount of work that the policy committee put into this product and the eagerness with which we anticipated being here on the 26th, I didn't want to derail us in any way. But I apologize in advance if I need a moment to use a Kleenex or the restroom, because that's just kind of the state of things in Michigan in February. So apologies for that in advance. There's a lot to talk about, and I know we're the sole agenda item, and there's a lot here that we need to digest and move through. But I want to talk very briefly to sort of level set with the board the process that we've moved through, what that looked like, and understand what we have in front of us. And so there was a memo that was attached when the working draft was circulated to the full board, the memo dated February 19th, and I outlined very briefly the review process therein. And you know, we've made no bones about it that where we started, things were messy. The policy manual, as it was constructed, as it was presented, particularly on the district's website, was messy, and it was hard to follow. There was some reasons for that. There was some deviation from our sort of standard baseline processes, and that's okay. But we needed to kind of get back to what do we have, and how do we get something workable to then move through a process of trying to edit it, trying to get feedback, trying to talk about what legal updates might be appropriate to the policy manual, so on and so forth. And so we undertook that work with the policy committee and walked through existing policies, walked through suggested updates that our firm had that we had sent to all of our policy clients over a period of time. And we had good, honest, robust discussion about a lot of those items. And you know, there's moments in those policy committee meetings where there are strong opinions. And I think it's important where we're at in today's society to not be afraid of strong opinions. I think strong opinions are okay. Civil discourse is the key, and being able to communicate those opinions in a respectful way, to be able to respectfully disagree. And I'm really proud of the work that the committee did, because I thought those discussions took place, that there was civil discourse, that there was respect for opinions that were advanced, even if there wasn't consensus that formed around them. And so ultimately, what we get is the draft, what I'll call the working manual, that is in front of the board this evening. And I've tried to explain in the memo sort of the color coding that we have there. There's sadly not a particularly effective way to do this without a whole bunch of color coding. But we've explained in the memo what we have. Really, if it's in black, sort of unimpacted text, it's in essence what you have now. If it's in red, it's something that is new. If it's in blue, it's something that is new and something that on which the consensus was not reached within the committee. But I think it's important to understand what we're talking about, because there's, I don't know, 45 some pages here. And if you scroll through it quickly, you're not going to see a ton of blue. You're going to see some red, but you're not going to see a ton of blue. And I think what's important to understand about that from a macro perspective is the process that the committee went through. The process the committee went through was to say, let's look at what's in this working draft. And do we have questions or concerns? Are we all sort of in agreement with what's there? And we use this idea of a parking lot, right? We hear this a lot of times in business speak and education speak. Let's put it in the parking lot for another day. We went through the entire manual from front cover to back cover and said, are we good on these, or is this a parking lot item? And there were a handful of parking lot items, maybe more than a handful in the first walkthrough. And we've set those aside for another day, another couple of days, and came back for additional discussions and focused in on those parking lot items. And we're able to move a lot of those items out of the parking lot and put them in red to signify change. But there's still a few as we scroll through that are going to be in blue and that signify that there was not consensus reached. But I want to say that because there's a lot of consensus in terms of what the committee has advanced to this full board in terms of its thoughts through that process. And that does not mean that there weren't discussions. That doesn't mean that there weren't respectful disagreements and all of those other things, because of course, in any policy process, there's going to be those things that happen, but limited blue. And so the intent is to, I know the board has had some time. I know there have been a few questions and comments that have been forwarded. The intent is to move through the manual with whatever speed we are able to do and see if there are questions. Obviously, the blue are questions, but I want to move through somewhat chronologically. I want to start with the student section, which is 2000, and then I want to work through the end of the manual, coming back to the bylaws. And part of my thought process there is that most of the blue is in the bylaws, and I think there's going to be hearty discussion around those topics, and that's great. But I also think there's a whole lot of consensus, 2,000 to 8,000, at least we saw in committee, that I think it would behoove us to start that process and move through that. Last thing, and then we can finally get to work. And I think President Butel said it to a certain extent in her opening comments. The agenda item is the policy manual. That's what the agenda item is, and that's what Adam and I are here to talk about. We have tried to view this process, and I have shared this with the policy committee many times. We are facilitators. This is your policy manual. This is the policy manual of the Board of the Rochester Community Schools. This is not Kevin Sutton's policy manual. It's not Adam Blaylock's policy manual. It's not the Miller-Johnson policy manual. It's Rochester Community Schools policy manual. And so our job is to help facilitate, offer our insights. If there are questions on what a word means, how it might be interpreted, where have we seen policies like this applied elsewhere, it's our job to share those insights. But the work here is to be done on this policy manual. I'm not interested in having discussions about other topics my firm has offered legal advice on or anything else like that. We're here to talk about the policies this evening. So if we can direct our attention to the manual, apologize for the long opening. We'll get to work on the 2000 section and move through and try to address questions and concerns as best we can.
I have a question before we get started. Can you clarify this opening statement you had? You mentioned it being a mess. What was the scope? You mentioned the committee started. What date did the committee start? Because again, you referenced in another email, it started in 2020. It's just really unclear what time frame you're talking about when the work was done. Are we talking about starting in 2020?
Yeah. Did I hear you reference an email, Trustee Weaver?
Yes, I did.
Yeah, and I think, if I recall correctly, that's the email that's posted on your Facebook page that I saw this morning. And I provide, I think, pretty significant detail in that email regarding the process. And reading it again this morning refreshed my recollection to a certain extent. I recall when the committee was constituted, I have no idea when the SPCC, as you call it, was formed or when it was told it was going to be undertaking this work. I'm not entirely clear on. I did reference 2020 in the email you mentioned, and I recall reaching out to Beth Davis, Miss Davis, prior HR director, on some topic. I don't recall if it was an OCR complaint, a Title IX issue, something that she had called me and asked me for some insights on. And I had gone to the website to look at the policies and was somewhat dismayed, just as a citizen, of how difficult they were to access. And I saw some dates on some of them that suggested they hadn't been updated since 2017. I knew that we had issued a number of updates as a policy service between 2017 and whenever I was looking at it in 2020. Admittedly, 2020 was a bit of a blur probably for most of us. And I remember expressing to her at that time that I was concerned with not only how difficult it seemed to be to access the policies. Like I could get the first page of it, but I couldn't see the second page. And she told me there was some series of keystrokes I had to use or something, and it seemed to be too difficult for the average person to access. And I expressed concern that they hadn't been updated. And so at that point, as she had said, sort of acknowledged that there was a concern there and that we needed to try to remedy that. That's what the reference to 2020 is. I think, if I recall the rest of the email chain, or maybe it's a subsequent email in that chain, I think I indicated a couple times that the work begins really in earnest in January of '23. Obviously, there was a transition with Ms. Davis leaving the district and Mr. Murphy taking over shortly after that happened. And Dave, I don't recall exactly when, but he reached out and said, hey, I think maybe you've been talking to Ms. Davis about policy, kind of where are we with this? And I said, it's in Ms. Davis's court. I've been waiting to hear and sort of move the process forward. And at that point, Mr. Murphy engaged and was very active in communication with me and trying to get the process jump-started and moving. And so, again, a long-winded answer, but I think ultimately in earnest, January of '23, but having its roots in sort of that initial me being on the website for some reason at some point in '20.
Okay, I appreciate that's exactly what I was looking for. That gives me a better idea of kind of the chronological order. I really appreciate that. Thank you. That information is very valuable.
Madam President, can you clarify what kind of work the SPCC did with the policies prior to 2023?
I was not on SPCC, so really that would be the superintendent or someone who was on that committee.
Is there anyone on this board who might have been on that committee prior to 2023?
Yes, I was.
Okay.
In
Could you
addition
answer
to
the?
policy, we also looked at curriculum, and there were several policy updates, some that are being maintained, some that are being stricken from the document we currently have.
So was the SPCC actively working on policies then prior to 2023 while you were on that committee?
We looked at policies when there were changes brought forward.
Okay, who would bring
Or
those?
updates.
Who would bring those changes and updates to you then?
Well, typically, they would come through an attorney and then go to the superintendent, and he would convene the committee, because that was his committee, and we would sit and listen to what the updates were. and
Oh,
what
that was
possible.
his committee. So the updates would go from the lawyers to the superintendent, and then the board would hear the updates through that process then?
Correct. And then, as by law, any changes to policy would have to go through a two-reading process before being adopted by the board.
Okay, so it wasn't the board actively working on the policies necessarily, but they would review updates?
I mean, we were aware of what the changes were, and we made comments if we felt that they needed to be changed. And we also communicated to the rest of the board what changes were coming, and they had an opportunity individually to recommend changes as well.
Okay, I understand. Thank you.
I would also say, I know that when I attended the annual leadership conference through MASB, and I can't remember what year it was, but there was an update on Title IX updates that needed to be made. So that was something that I brought back because I had not seen that in our policy. And then there were some changes made to be sure that we were meeting those qualifications. Okay, I would like to, let's now move to the policy that we have on hand.
Okay, great, thank you. I'm going to direct everybody's attention. I think everyone either has a digital copy or a hard copy at this point. We're going to look at the 2000 series, which is the student section, page 8 of 41 in the copy that I have, though admittedly, depending on what printer you use, it might look a little different. I think the most effective way to do this, because obviously there's a lot of material, is to sort of go through somewhat slowly and say, does anyone have any questions? Obviously, the board has had this for some time. We've provided the context for the red versus the blue versus no colors at all. And so we'll do our best to address those questions. And so I'll start with 2001, the admission and enrollment section, and the changes that have been noted thereunder.
I do have one question on this. The very last section, shared time instruction. My question was, because this is for, if I'm reading this right, this is under the non-resident section, and it says, it talks about non-resident homeschooled students. How or when could a non-resident homeschooled student qualify for shared time instruction?
So to be clear, and it's not intended to be under non-resident students. It's a separate section under admission and enrollment. So there are in essence 3 sections under admission and enrollment: resident students, non-resident students, and then that reference to shared time instruction. And so it's not a subcategory of non-resident. It's its own standalone.
Okay, let me ask you then, how is the homeschooled section different from shared time instruction then?
How is the homeschooled section different than?
Item 2,
I-
paragraph 2.
The second paragraph at the top talks about homeschooled students, and then,
The law makes a distinction between those two categories. So shared time instruction is often going to be, and so most commonly we see it with public schools that are offering shared time opportunities in conjunction with some of the parochial schools in the area. Homeschool is a completely different category. And so there's a distinction in the law between those two kinds of accommodations.
okay. And I'm sorry if I'm beating a dead horse, but under shared time instruction, it talks about as well as eligible students who are being homeschooled. So I'm just not sure that I understand the difference.
Is this referring to when public school teachers teach at private schools or might teach groups of homeschooled students? And then the school district can collect FTE for the time spent?
So yes, and I would clarify that that is also potentially true for homeschool students. I actually had a high school friend of mine that was partially attending our high school, was partially homeschooled, so. It's uncommon, but we do see it on occasion.
One thing I was wondering regarding both of those sections with homeschooled students and shared time instruction is if there's a way for the board to maybe create some policy around that so that we would be able to offer more options for homeschooled students who might want to take classes in the public school, because then it could be a mutually beneficial opportunity for us where we can collect FTE dollars that way, and homeschooled students who live within our boundaries can also attend classes that way. And so I was just wondering what kinds of options we might have to do something like that.
So I think the short answer to your question is, yes, the board can create policy that governs those things. I think that's a different group than the group that we have at the table today to answer some of those questions, because that'll depend a lot on some of the operational needs of the district. And so I would also want to defer to some of our administrative team on the decision-making associated with those things. But I think the short answer is yes, you can create policy related to that.
Well, and additionally, there's some specific statutory guidance around homeschool students and homeschool programs. And so, yes, to Adam's point, policy can be created, but we obviously would need to do that with the applicable sections of the revised code in mind.
Right. So who would we reach out to if we were interested to do something like that?
I think certainly those are the types of discussions that the SPCC can have to talk about ideas. I think Adam's point of not this group is that's when you're talking about crafting language, we can come up with an idea and say, well, does this work? It's a matter of checking to make sure that there's nothing that's out of legal compliance with doing it. When it comes to homeschool students as well, you're talking about certain requirements with the MDE that have to be met, reporting requirements and whatnot. And so I think Adam's point is we can craft language, we just have to make sure that it works. I think, what really our mindset as facilitators of this process and as practicing attorneys is to help the board achieve its goals. I don't want to say that we're going to be down for whatever unless it's illegal, because that's a little bit too broad of a statement. But I think, generally, whatever ideas come, we're happy to vet them and make sure that there's compliance, or if there are compliance concerns, to see if there's ways that we can craft language that would help navigate around those things. Yeah.
So I guess I would just say that if there was something that you were interested in, you should talk to your board colleagues to see if you have sufficient support for something along those lines, and then we could take it to the administration to see if they have we have the bandwidth to be able to do something along those lines.
Absolutely. I've actually already shared all of this information with all of my board colleagues, so happy to continue the discussion.
Trustee Weaver, did you have a question on
I have
2001?
maybe a little different question, and to make sure I understand. So what I'm hearing kind of from it is, how do we get the parameters and what basically is what we can do? Because again, what I'm kind of hearing is, how do we go into this saying, what is the maximum way that we can provide as many opportunity to as many residents inside our school district, which again says, hey, we want to make sure we're offering as many opportunities to our homeschoolers if we can try and bring them in. So how can we get that list, basically, or those parameters? Because really that's what we would need, this idea that a board member should be going out and sourcing something and bringing to the table is kind of the backwards way to do it, in my opinion. It would be, hey, what is kind of the big picture? If we said the goal is we want to provide as many opportunities to residents that can come here, which means looking outward to homeschooling or whatever different classifications fall under here, and then being able to assess it maybe in a committee or however we do it within that framework, but the goal being what is the maximum way we can do it, and really then we can work our way backwards of, hey, here's the maximum, but you're right, we can't really either afford to do this or it's not feasible, and work our way backwards off that maximum list. How do we get that list?
Yeah, I think it's a great question, and I will tell you that, you know, generally, when we're talking about new policy, things that maybe haven't been contemplated, things that we maybe haven't provided an update on, generally happens one of two ways. One is I have board members that draft something. They go to a conference. I don't know why this example always sticks in my head, but a couple years ago, someone had gone to a conference somewhere and they came back convinced that they needed a policy on drones. And they had written a policy on drones, and they were just adamant that we had to have it. And we worked back from what they had crafted and talked about some of the parameters around that and FAA regulations and all that other good stuff. That's one way that it happens. The way it mostly happens is we as a committee, we as a board have an idea or we have a goal. Can you come up with something to help that we can sink our teeth into, that we can talk about, that we can edit? That's the way the majority of it happens. Either way is fine. And so you mentioned the committee or the board, excuse me, being able to identify what that goal is. Knowing that obviously helps us craft. And, you know, in terms of the list of what would we do, you know, the immediate thought is, how do I write language that meets the objective of what you're trying to do? Then I'm going to go look at MCL 380.1561, 388.1766B. Then I'm going to go to the MDE's page on homeschooling, because they have pages and pages and pages of guides on homeschooling and pupil accounting aspects of it and all kinds of other stuff. And we're going to pour over that and make sure that once we've crafted language that meets the goal, does it work legally? Or are there contours that we need to add to it to make sure that it works legally? And so that would be the list or the source against we would be checking to try to achieve the objective that's been outlined by the board.
So in this case, would that fall under, so say we wanted to go that route, right? So the vision is we want to create as many opportunities as possible for every resident, whether they're enrolled full-time, part-time, homeschooling, whatever. Would then we be looking, would that be added underneath the shared time instruction part of it? Is it a standalone policy? I think that kind of goes back to President Patel's first question, like how does that just structurally fit into this puzzle?
And so I'll share, because I've literally gone through this policy manual with another district in recent months, right? And we did some of that work. The short answer is it depends a little bit, and I hate to give the lawyer answer, but it depends on exactly the things that Kevin just talked about. The reality is it may fit under that shared time instruction, it may fit better somewhere else. And so the answer for now is it depends. But what I'm hearing and my takeaway is we need to pull up some of the parameters related to shared time instruction and be prepared to share that with your policy committee. And I think I just got an assignment for me to do it tomorrow. So
I would ask that it be shared with the entire board. I think that the trustees should have a right to still look at it and give feedback.
Okay.
Well, Madam President, I suppose I should ask the question. I shared this information with the board on January 14th. I sent a follow-up on January 31st. Trustee Gupta recently received information about this. Do other board members have interest in this information, just to help understand if this is something we want to pursue?
One, I'd ask, before we continue down this line, we're here to cover these items that are on this. So I'm saying we could discuss that at some point, but right now, I would like to get through what we have here. And if we sidetrack, we're just on the first item, and we haven't gotten through it. So I'd like to get through this, and maybe we can create a page where we put these items down, and at the end of the meeting, if we still have time, or we can address them at another meeting to bring those up.
I'd be happy to create parking lot 2, and we'll have it in parking lot 2 or any of the
Yeah.
items that come up
I think
as
that would be
potential
great.
new additions. That's,
Yep. I'd like to try and get through what we have, and then we can talk about any additions. So did anyone else have anything on
idea.
2001?
I'm sorry, so what does that mean? Because this is about one of the items on here. Do we want to flesh it out more?
But it would be
So
in
does that mean
addition
this
to
is-
it.
Well, it's in our policy, so is this something where it's like this is our parking lot too, this is now a topic that we can keep pursuing?
That's what we're asking him to put it on a list, and we'll go from there.
Okay, great, that
But I
sounds
think
good.
I'm not sure we're understanding. We're talking about we would discuss it later. Not that we're asking them to go create a policy. We are going to discuss it
board- the
after we
board
get through
creates
all the
policy.
policies.
The board creates policy.
Right,
Again,
which
they
is-
were- we're asking them to provide us information. That's all I heard from this conversation was go source some information and let us see it.
But
so
we
can
would
start
need
looking at
to,
it.
we would need to vote if we want to move forward with that, right? Because that would be additional expenses. And what I'm asking is that we get through what's on here, and we then come back to the items that we want to discuss for possible
So, Madam President,
additions.
in this process, when are we going to address the parking lot 2 questions? When's the next meeting that we're going to
It
address?
depends on
parking lot 2?
whether, how far we get through this. I mean, we might be able to address it today if we get through these things, but if we don't, then we're going to have to figure out, maybe we're adding meetings. I mean, we already have several meetings on the books.
Just trying to understand what the plan is.
So
I guess I just don't understand what parking lot 2 means. What exactly
parking
does
lot
that
2
mean?
means that once we get through everything that's being presented tonight, that then we could begin discussing any potential additions. That's, in my mind, what we're talking about.
Oh, so we're ignoring it for right now, and we'll get back to
We're
it at the
putting
end
it
of
on
the
the
meeting
list.
if
Correct.
there's time.
Correct.
Okay.
So
Trustee Alsbach?
as we go through this process, are we making
Trustee
any
Weaver,
changes?
I've asked, Trustee Alsbach asked to speak.
So I think this is a really interesting topic that I'd like to learn more about. But what I really think is this is a whole new idea and maybe even a vision. So I would suggest that that be its own agenda item. And President Butel, correct me if I'm wrong, but you have said if 3 of us support putting something on the agenda, that we would do that and we'd let you know ahead of time. And when we're having this discussion about homeschoolers, it can be a little bigger than just our policy, because we also have to look at the pupil accounting manual, because we have to make sure that we're getting into funding. If we're talking about sports, then we have to look at MHSSA. So it would be a different, that is a topic of a different type of nature. So I'm not opposed to putting it, to talking about it, but I think we would need a different group here to have that discussion. So I would suggest that, rather than this parking lot 2 thing, if we have support to put it on the agenda, let's put it on the agenda and plan for it and get the right people here.
I'm going to go back and say that I understood the question was be just to get information so we could even start digesting any of this, if that makes sense. Again, we're acting as if somehow board members on this table are just going to magically create an idea. If they don't provide the whole part of this conversation of being able to say, hey, what are the parameters, start digesting it, how good's the next conversation going to be?
And I
Instead of
agree
saying, oh,
with
we're just going to
you.
have them bring a policy to us.
I agree
that-
with you that if we wanted them to start digesting it and in giving us information for it to see what our boundaries are. However, I'm really not interested in incurring legal fees until we get the board is willing and going in that subject. So just a singular request from one board member or 2 board members is not the board. So I think, and it's a different audience and a different set of experts. So if we want to go there, I think we need to be intentional about it and get it on the agenda.
So we're
Trustee
putting on the
Gupta?
agenda to request
Trustee
information.
Weaver,
I'm
Trustee
following-
Gupta has
Oh my
been
God.
recognized.
So to me, what's logical here is if we've got this new idea that we want to explore, or that some want to explore, that has major implications on operations and finances, that we would need to first start collecting information from the folks in those areas in our district to kind of evaluate feasibility. That's the only way any member of this board could make an informed decision about whether or not we should then go further and invest resources in legal opinion on policy. So to me, just the starting point, I'm open to exploring it. I just think the starting point is not in this moment, in this place.
Trustee Weaver, did you have a comment?
I'll let you.
Trustee Blake?
I just don't think we're ever going to get through this if we start thinking of our wish list of ideas. We should talk about each one in here. What do we think about the things that are in here? And if we're coming along and we think of an idea, oh, we need a drone policy, put that on your list, and we can talk about the drone policy later.
Yes, so I think we need to, if any, did anyone
No,
else have
I'm
any?
going to ask my question. I don't understand the logic that we were hearing, though. How can we go to, again, how can we go to Mr. McDaniel and say, tell us what the business plan is or how this financially affects you, but not tell you what it is we want you to do? Like, the whole point of the conversation, which was started, which I thought was very good, was we have to start with what are even our options, what are the parameters, so that we can then digest it and say, as a board, what does that vision look like? That's when you would go to our business team, our operational team, and say, hey, this is what we're thinking. How do we do it? Here's the what. Can we do this? How do we do this? But if we don't have that piece first, I don't get how that conversation even starts of any
If you
matter.
just want to read the items, as he said, you can go to the MDE under homeschooling, and in here, it's referenced MCL 380.1561 and 388.1766B.
Got it. I got it. You guys are just waiting for someone to hand you something and got it.
Okay. Mr. Sutton?
Okay, is that all the commentary there is on 2001? Okay, then I'll go to 2002, which I note doesn't reflect any changes. In the hopes of moving us, I'll go quickly if there's no objections or no questions on 2002. Again, I've assumed everyone has read. 2003, on page 10, we get to our first blue highlighting, which again, reminder, that meant parking lot and a lack of consensus within the committee. And in fairness to the committee, this was a recent update that we provided to all of our policy clients on a phrase called limited directory information. And since we talked about it as a committee, and I think one of the trustees posed a question, I don't think I did a good job answering it during our policy committee meeting, so I'll try to do a better job now, and Adam will jump in if I'm inadequate. This idea of directory information, which is just above that, directory information is a category under FERPA, and it's, FERPA information is generally education records, things that are of a personal nature, and directory information are items that the school can designate that are not overly sensitive, they're not personally invasive, and the district can release directory information, generally speaking, without FERPA considerations. The government agency that monitors FERPA compliance, it's called the SPPO, I think it's Student Privacy Protection Office. They change the name of it every couple of years. The SPPO has now gotten into this category of limited directory information, and they talk specifically about photographs, videos, other media containing a student's image or likeness, and then district-issued email addresses. And the best we can discern from the information that the SPPO has put out is that because they're seeing a lot of opt-outs of directory information because of name, image, likeness, and email addresses. And so they have created this subcategory from a regulatory standpoint of limited directory information, identifying those things specifically and saying specifically what they will be used for, all right? We are not required to adopt this language. This is simply the SPPO trying to respond to people taking a general opt-out because they're specifically worried about this. And it makes some sense. We see obviously in 2024, most districts have, whether it's a website or social media, photos and so on and so forth. And so we see more parental concerns, more parental opt-outs on that front. And so the suggested update of limited directory information was the outgrowth of some guidance from the SPPO and trying to make it a little bit more palatable and having limited uses for that information specifically. It would note that it also would overlap then with photograph being listed above in directory information. If we were inclined to accept the limited directory information, we would make sure that the directory information language matched as well. Hopefully that was a better explanation than the one I provided to the committee a few weeks back.
Tell me just that photograph piece, what did you mean by that? Photograph would come out of directory information?
I think
or-
we'd want to probably take a look at that, because if we're referencing specifically that photographs and videos are limited directory information, having photograph in the directory information definition seems like there might be some confusion around that. And so I would probably suggest that if we were going to adopt the limited directory information language, we would probably take out the second bullet point in directory information, because it would move from being directory to limited directory. And for those who are not particular fans of policy, talking about this is enough to make you want to tear out whatever hair you have. I can appreciate that, but that's why Adam and I are bald. But that's very much driven by regulatory feedback from the government agency that monitors FERPA compliance.
Well, and I guess I directed to the SPCC committee as far as what was the concern here in adding this, or what was the issue with it?
In fairness, I think the concern was I didn't explain it really well at the time when it was asked, and I might have been trustee Lakua you asked, and I gave a somewhat vague explanation of it, and we were very early in our parking lot meeting, and we were trying to move things along, and we said, we'll parking lot it. I don't recall us having a particularly substantive discussion around it, other than my, now fourth time admittedly haphazard discussion on it.
Trustee Lakui.
I guess a couple questions that I still have, just based on how it's worded here, is would we need to specify who has produced, the photos, videos, or media that contains a student's image and stuff? Like, it's not like images taken by parents and stuff would be owned by the district, but the way this is written, it's just a little bit, some of these things are a little unclear. Or does this mean we can't share stuff that the district puts out? Like, it's only shared district posts and things that they put out?
So generally, information that's identified as directory information is disclosable because it is no longer protected by FERPA. So the response, the creation of limited directory information, is really intended to narrow the scope of that opt-out in order to encourage more parents to not opt out to everything. So when we look specifically at like publication and district publications, think of your school newspaper. And think of a student that's been opted out because of any concern about any number of pieces of information that's not able to appear in the school newspaper because their parent was concerned about them being published in the free press. And so again, this is a tiny little regulatory offshoot that we struggle to explain because of that.
So my question then would be, from a standpoint, the intent of a policy is either to allow something or not allow something. Is this policy, because how you just kind of explained it, I was going to ask more for like a real life example, but I think you kind of provided one. Is this really policy designed to make sure we know what we can share? So to violate this policy, what would we do to violate this policy?
So the violation of the policy would be a parent that has opted out of both directory information and limited directory information and publishing a picture in the school newspaper. That's
Okay.
the example that I'm thinking of.
So then I go to this. To me, this isn't clear. Why isn't this clear to just tell us what specifically, how can we make it more clear to specifically answer that question? How do I look at this and say, if a person is opted out of this, this, and this is what you can't share?
So generally speaking, and I'm not, I don't have firsthand knowledge of Rochester's particular protocol, but generally what FERPA requires is the district to issue annual notices. And most districts send those at the end of the summer, right before school comes back. Sometimes it goes out in the first newsletter, and all of those notices are provided. And it's not just directory information. There's other things that go out. Those of us that are parents, we know we get the 47 papers that come home the first few days, along with the cards and all that good stuff, unless you've gone digital. Those forms contain the opt-out request, right? And so the district has generally latitude in terms of how it prepares those opt-out forms. And so I think particularly because this is really nuanced, I think if the board were to, the district were to provide those annual notices with the opt-out form, maybe giving examples in what the opt-out form would mean. I tell the story, I've told the story for years. My son was younger in an elementary school, and the teacher had a Twitter page. And everyone was getting on Twitter. I know it's X now, but it was Twitter then. And I see a picture one day of the kids on the playground, and I know it's my son because I got him dressed that morning, and he has a little paw print over his face. And I thought, well, that's weird. And then a couple days later, there's another photo, and I know it's him, and he's got a paw print on his face. Now I'm starting to get agitated. Third time a photo, paw print on his face, and I think, what, does the teacher think my kid's not cute? Why does she keep putting a paw print on his face? As I had been filling out all those forms on my desk, I signed the media opt-out that said you can't post them online. And so she was dutifully taking photos, but covering his face, so you couldn't see it. And so I think providing some degree of clarity in those annual notices will help members of the community understand the difference, the practical applications of them. And again, I think what SPPO is trying to do here is not get people to opt out of directory information entirely, but recognize that there's some sensitivity, particularly around photographs of children and what goes out, and trying to give parents an avenue to do that while still preserving the rest of the directory information.
Yeah, because again, I go back to, I feel like any policy we write, that's exactly the intent, is that one, in this case, where a parent can read it and know exactly what they're opting their student out of, but also for our employees, they know how to make sure they don't violate. I mean, the goal is not to violate policy. I just would say, as I'm reading this, I don't know that this helps an employee or a parent really know what this means.
I guess I would just ask on the photograph piece, because I think I had heard in the past that the photo was included in there primarily for athletics at the high school level. And so this is more a district question to know if we remove that, does that mean if someone didn't want their photo on social media, that then their photo wouldn't be in some form of athletic book or something along those lines? And I don't know if anyone from our administration knows that. Is that fair? Okay.
To me, again, to that point, this is where I think, again, policy has to be more detailed, because I would think when you sign up to be on a sports team, that might be part of that agreement, is when you sign up to be on the sports team, you're going to be publicated in certain things. Like, that's where policy has, I think, each area might differentiate. This, you might have a standard student one, but athletes, you fall under this category. And again, that's just part of being an athlete, maybe. Again, you can decide how that goes, but that's,
But
I think, the
I
level of
would think
details.
it becomes difficult if a parent opts out of one, but then doesn't on the athletic. I mean, there's overlap there. I think that would be the difficult piece to have two
Well,
conflicting.
and I guess I would just say, recall, we're talking about the limited piece, but the directory information piece is still there, and that talks about participation in school district-related programs and extracurricular activities. A student's height and weight, if they're a member of an athletic team, contemplating that we put out these program books. Sometimes the booster clubs do them, and, hopefully we say people are taller on the basketball team and all that stuff. So that information is still there. I really do think that the answer, and I think it's a very good discussion and a great question. I think the answer really lies in making sure that the opt-out form is detailed. This is providing an avenue for the parent to do that. It's pointing out that there are rights and responsibilities that parents have. The onus, particularly under all the FERPA interpretive guidance that is out there, is on the district to offer a form which allows the parent to make an informed choice. To the extent that we're getting super nuanced with limited directory information, review of that form and making sure that it does provide meaningful information to parents so they can make an informed choice on whether or not to opt in, opt out. Excuse me, to opt out. Opt in is you're assumed to opt in, but to opt out, I think, is important. I think that is where the answer to the question lies from my perspective.
Okay, Trustee Alsbach?
I think offering the directory and the limited directory information, correct me if I'm wrong, could help teachers, because then, some parents have a level of sensitivity about their child's name or some of this directory information. But if Ms. Jones is just snapping pictures at a field trip, you never want to say, oh, honey, mom opted you out. Could you step out of the picture? So I think, correct me if I'm wrong, so a teacher would be able, if no one had opted out of the limited directory information, she could celebrate the kids in a more inclusive way.
Yeah, Trustee Alsbach, that's a really fantastic observation, and I can tell everyone in the room that's happened. I had a situation about a year ago, it was not in Rochester, but I had a principal who was bringing students down, they were celebrating something, and a young lady came down to take a picture. It was her and another girl from the class, elementary student, and the principal knew the student had an opt-out. And she said, sweetie, you can't be in the photo. And obviously the student was devastated, and that turned into some contested matters that got filed with the Office for Civil Rights. And so that happens, and it's not for lack of desire to have our students celebrated or things like that. So I think that would be one practical benefit of it, yes.
But Mr. Sutton, you bring up a good point there, that difference between excluding the student from the event where the picture is taken or putting the paw over their face. That's where, again, the policy needs to differentiate. I would think, again, policy would say you're not trying to actually be uninclusive of the student. I think we would expect people to understand that piece of it. But then knowing, okay, we just can't publish the picture, or you do the paw print, and then you can look at the parent and say, that's your choice. You talk to your kid about it. But knowing in the moment of time, creating that event in a classroom, in an assembly, again, policy should be clear on that, again, to protect not put our teachers in a position where they have to make that decision. Look, this is only solely about the publication of it, anyone that has an opt-out, we deal with on the publication. Don't ever create a scene inside your classroom or in a gymnasium in front of other students. I think that goes to some common sense, but yeah, that should be called on the policy. We're talking solely about publication.
And I'll just ask on here, directory information and limited, you could opt out of either one. Is that correct?
Correct.
All right. Anyone at this point have objections over this? Is everyone, Trustee Weaver?
Yeah, I object. It's not clear. So from
Okay,
the beginning,
so-
we couldn't even, I mean, and no shame on them, like, it's not clear what it is. It's not clear on how to do it. No way would I say that this is something I put out in front of someone and think anyone would know how to implement this, how to make sure they don't violate it. I mean, even just this whole discussion we just had.
I guess when I read it, I have a pretty good idea of what it's saying you can or can't have, and I heard that the specifics would be on the opt-out form. So I guess, Mr. Sutton, did you have any other thoughts on this as far as making it clearer or addressing any of the items that had been brought up?
I have nothing else to add. Thank
Okay.
you.
I
Trustee
agree
McQueen?
that it's not clear, and the point is to just be as clear as possible. So I would prefer not to support it as it stands
So
right now.
what, do you have alternate wording for it? Or you would just say, you just want it to be the directory information and not having the other, is what you're saying?
It's optional, right? I would just,
So
Say
if we
leave it
have
off.
the directory information, just to be clear, then, I mean, any of it can be released. It's just a matter of there may be more people who opt out of it.
So I think, and this is perhaps a little bit of a unique component, because this policy is talking about really the implementation of FERPA and our obligations under FERPA. And so whether or not we adopt limited directory information with this specific language or modified language, it's still provided by the SPPO and it's still provided under FERPA. And I would still tell the district that you need to modify your opt-out form to reflect that. I think the important part of having it in here is to provide notice that it's something that we have contemplated as a board. It's something that we're aware of. And because we don't want to play gotcha with anybody, we want people to know what's there. Instead of saying, we've never mentioned it, all of a sudden someone comes in with a limited directory information waiver and everyone says, what the heck is limited directory information? There's been a policy statement on it. So if there are suggestions for revising it to make it more clear, I think those are worthwhile contributions. But ultimately, FERPA is going to dictate this issue, not board policy.
Trustee Alsbach?
I would support adding the limited directory information because I think that parents may be sensitive about some of the information in directory information where they may be willing to have their child's image in celebration photos. I understand the concerns about this not being specific, or I think it is specific enough, but this is a policy. So this is something that operates at the 10,000-foot level, and where the clarity and making sure that parents understand what they're signing or not is in the form. So, you get down to your admin regulations, and then you get down to your processes and procedures, and that's where it gets, this is more, which is why we have the two of you here, this is more lawyer speak. It's not all that friendly. So that's where we would get to clarifying all of those concerns would be in the actual forms.
I
Trustee
don't
Weaver?
really agree with that statement of how policy works, but then even if we're going to operate under that premise of policy, then I think our policy would have to then outline specifically what was required of the form, because then how else would we know that that requirement's being met? Again, it goes back to what's the violation of the policy. If so, again, I would go back to, I think it could be clear around the limited directory information, specifically calling out what is it, if we do this, it's a violation, if we do that, it's a violation. But if we're just going to go to, we're going to put this out there and hope a form qualifies for it and hope a form meets the standard, I think then the policy should require what the expectation for the form is, so that therefore, again, the employees that are developing that form can look at the policy and say, oh, does my form meet that standard? If that's not on there, then again, how do we know the form meets the standard?
So
That's what the policy has to be.
I can speak to that briefly. And there's a second half to this process with administration. Someone referenced administrative regulations. And as part of our baseline package of administrative regulations, we provide an opt-out form. And so it's in the administrative regulations, which of course are shared with the board. So the board can make sure that the administrative regulations are giving operational effect to the policies that they've adopted. And so we haven't gotten to that piece of the equation yet of doing the administrative regulations, but I think Trustee Weaver raises a fair question of hope is not a strategy. And so how do we know? And I think my answer on this would be we provide an opt-out form which will have limited directory information. It'll be part of the administrative regulations, and those administrative regulations will be shared with the board to ensure that they've met the call of the policy.
Trustee Annis?
Based on what you just said, I would support the inclusion of this limited directory information policy language.
I just had hopefully one last thing. Under the directory information where it says a student's photograph, can we be specific there? Like, could it be a student's class photo or photo approved by the family or something like that so that it can be included into, you know, potentially some booster club?
Yeah, I would say that the FERPA regulations provide the district with the latitude to create the categories of directory information. And so parsing photograph into types of photograph is something that the FERPA regulations would permit a school district to do. So the answer is yes.
I would lean towards that direction just since photograph is listed in both, but to call out specifically what it applied to.
I think that's fair.
So going back, Mr. Sutton, what you said, so what you described with the administrative regulation, I just think for our community, they need to recognize this is just a fundamental difference with how you guys write your policies versus like a Neola. That's just a fundamental philosophy difference between the two. But then I would say that what I'm saying is the call out, what you're saying as far as your process or the administrative regulation, when I say what the standard of the form, that should be listed here. That should be clearly called out so that there's that line of connection from this policy to that.
I'm not sure if that was a question or a comment, but I'm happy to respond to it either way. You're right that there is a fundamental difference in terms of how we draft policy versus, in particular, the policy provider that you identified. There's a reason that just about every policy client that we work with formerly worked with that policy provider. They grew weary of having hundreds of pages of policies that handcuffed the operation of the district and decided to move away from it. That doesn't necessarily have to be what every district does, but the majority of the districts that we work with have moved away from that other provider for that reason. The key, from our perspective, is to make sure that whether they're all lumped into one big manual or they're separated out between policies and administrative regulations, the fundamental key here is that the administrative regulations, in good faith, give operational effect to the policies that the board has set. And that's why the sharing, the distribution of administrative regulations to the board, and we've got language in blue that we'll get to at some point, maybe tonight, about board action being required or not required on administrative regulations. But the key is that the board knows what the administration has come up with, that they can look at it and say, and I mean, give a basic example, and obviously this is oversimplified for discussion purposes, but if the board says, we're going to pass a policy that the school colors in every single building should be green and white, not only would I fully endorse that policy, but, and the administration comes up with regulations that says, make sure every fall we go and paint everything blue and yellow. Well, that obviously would be a regulation that isn't giving operational effect to what the board has said. That administrative regulation would come, the board would look at that and say, excuse me, superintendent, this is not giving operational effect to what we've passed as a board. Please go back and take another peek at it. And so that I don't want to call it a check and balance or a give and take, but that working in unison, because the board establishes those foundational principles. And it's the job of the administration to draft those regulations, the X's and O's, the blocking and tackling, if you will, that brings those policies to life. And you're right that there are different philosophies on doing that this is ours, and it's served us and our clients well.
So let me clarify, and I apologize, that was not in a way meant to be a shot at you guys. It's just saying fundamentally there's a difference. And again, a lot of people will consider Neola a gold standard. People make decisions. I was specifically referencing just when we talked, my point about having the standards for the form, and when you said your process is the administrative regulation, all I was suggesting is we should have listed on here specifically that the administration regulation will encompass X, Y, or Z to meet the standards of this. I thought that's kind of what you were saying, so really I was just calling for that to be added to this one specifically. Now, I was not meant to challenge what you guys were doing from a philosophy standpoint, but I think that would at least be to the point when you read it, the person would say, okay, here's what it is. I know now to reference this administration regulation, that's where I could see what the actual standard of the form is, and then, to your point, can do the back check. Does that standard meet that?
Yeah, no, and I didn't take the comment as a shot. I appreciate the dialogue, and you're right that there are different approaches to it. I'll leave it to the discretion of the board whether they think an addition would be necessary. I would note that there is reference in the directory information to objections, which is opt-out being made in accordance with FERPA. If you wanted to add language that says the superintendent will develop administrative regulations and forms that comply with FERPA or that comply with the regulations under FERPA, I think you can certainly do that. The question, though, is where does that stop necessarily? Are you then going to make sure that you've called out every single instance in which you've wanted the superintendent to develop an administrative regulation? Again, I know I said it at the beginning, and I'll say it again. It's Rochester Community Schools Manual. If you want to do that, you can certainly do that. But that would be my only counter to that of once you go down that path, then you might not just be that one. You might end up wanting to do that on every single policy, or at least a majority of them, and that can get cumbersome, but that's obviously to the discretion of the board. I believe as drafted, it's clear, and obviously we would want to make sure that the form would be in compliance. And again, we provide those annual notices as part of the administrative regulations, and then year over year we provide them to districts that are members of the policy service, really as a courtesy to ensure that they've got the latest and greatest from an annual update standpoint.
I guess I'm confused from just what I heard from you. You're saying, again, we're not to that part yet. It's the administration regulations. It's down the road. It really sounds like that already exists. What would be the harm of what already exists, just referencing that it exists? I mean, I get what you're saying, that we could reference them more times, and if anything, I do believe over-communication is better than under-communication, but if we're just referencing something that already exists, that's part of your package, I'm just trying to understand what would be the harm in referencing that it exists.
Yeah, no, I appreciate the question. It's a good one. Let me clarify just so everyone in the room understands when I say that work hasn't been done versus we have it. The work of developing, updating, modernizing the administrative regulation manual for Rochester Community Schools has not yet been undertaken. We've not had the discussion specifically, but I've done work, as has Adam, in a number of districts where very often, because of a desire to move the process, boards or committees might say, well, geez, could we do the administrative regulations at the exact same time we're doing the policies? And we're always resistant to that because, bless you, because you need to finish the policies to know what they say before you can go draft the administrative regulations. So when I say we've got it, we're not going to, when we sit down to work with Rochester, it's not going to be the first time we've put together an administrative regulation manual. We have one. We obviously have a baseline that we work off of, and we provide it to a number of clients. And so when I say we've got it, we have the form, I'm talking about what we have in our catalog of resources to provide. But we haven't undertaken that work yet in earnest because we want to get the policies done and have them clear. To your question of what's the harm, again, I'll defer to the discretion of the board. I'm not saying that there is or isn't a harm. It's a suggestion that one of your board colleagues has made. I'll defer to the discretion of the board on whether you think you need it in there or not. We generally present our updates, and this was an update, with the language that we think you need and the language that we think is appropriate. It doesn't mean that we're infallible. It doesn't mean that a particular board might not have a different feeling on it. But we've presented the language that we think makes sense. If the board, and a majority of the board wants to make an addition, that's certainly within the board's discretion to do.
Well, we could certainly have something on the front of our policies that indicate that there are administrative regulations that apply to the following policies. Something generic along those lines and with a reference of where those were. Correct.
Madam President?
Trustee Lecoui, yep.
Oh, just to answer your question, I mean, yes, that's something that can be done. You can accomplish that with an appendix, you can accomplish that with a table, you can accomplish that with fun footnotes. There's lots of different ways to do it. Those are all options, yes.
Trustee Lecoui.
Are the administrative regulations something that the SPCC committee also discusses and reviews so that they may see what operational effect takes place according to their board policies?
That has not been the practice in the past at all. It's a superintendent responsibility for doing those, and then the full board gets them 30 days before they become live, so that the board has an opportunity to review them and could say something at that point.
Okay. I was just curious since it's called Superintendent's Policy and Curriculum Committee, so.
I guess that would be at the choice of the superintendent as to whether they wanted to address those at that time.
So again, I guess I'm going to go back to, I'm hearing you want the board to make a decision, but literally I'm asking to try and understand the pros and the cons. And if this isn't something that comes from you guys, I find it hard to feel like, how would you expect any client to be like, oh, what is the issue with adding, if there's a policy that directly ties to an administration regulation, why would we not connect those together? And again, you don't have to repeat yourself. You're going to say, we don't really have a why not or why not. It's the discretion of the board. Well, to me, the case would be, why would we not want to over-communicate if there's no negative coming from your guys' side, like, hey, it's wrong, this is the problem it causes, then yeah, I would say anytime we have an administration regulation that is directly related to a policy, we'd want to call it out so it's clear and straightforward. Here's the policy, here's the administration regulation. Oh, that makes sense.
So if I may, functionally, that's what it looks like. Ultimately, the administrative regulation manual that we have has numbers that correspond with the policy numbers that they implement. Not every policy necessarily needs an administrative regulation, though many do. And so ultimately, once we work through that administrative regulation process, what would likely you'd see is in 2003-R regulation, you would see those documents, right? But ultimately, again, as Kevin mentioned, we wait on making sure that we have final policies because, and again, I've just gone through this process with another board recently. They make changes. They have unique nuances. And so we want to make sure that we have those finalized and ironed out and approved before we go through and develop implementing administrative regulations because we don't want to have to go back and do that work twice.
Okay, so that makes more sense. So you're saying if we were to adopt this or a version of this, then once the administration regulation comes back, it gets added to it. So it's just a process step.
The administration regulations are typically a different document that has a corresponding numbers so that you can see the correlation. If it's a form that needs to be under policy 2003, it's 2003 AR or 2003 AG. So there is a correlation directly to them. Administration regulations have a different change process. So one of the things to think about if we want to embed language like the CAR 2003, one, right now it doesn't exist. And two, the administration regulations are typically written by the administration. They are operationalizing the policy, the vision that we've set forward. So because there's a different change process, but I think when you want to tie and reference and kind of do like a citation, the final admin doc would have the exact same numbering system so that tie and citation would be evident in the two different documents, would be my thinking.
That makes sense. So again, so in this document, when it's finished, and administration done, when this whole process is done, would you read this policy and would you be able to clearly see in this policy, would you see that there is an administration regulation and be able to locate it?
And it seems like such a simple question. That should be a yes or no. And I appreciate the reason you're asking it. Trustee Alsbach actually explained the administrative regulation process probably better than anyone else at the table could. We have not gotten to a point of having any discussion about, again, you asked at the beginning, Trustee Weaver, sort of how this process started, and the district has been hosting and posting its own policies. Very difficult to find, very difficult to follow. Ultimately, what the majority of our clients are on is an interface that we've contracted with a company to handle, where everything is I don't know what, indexed, down the side margin, you click on it, everything expands, you click on it, and there are hyperlinks to everything. More importantly, if you went to the search bar and you typed in photograph, whether it's an administrative regulation, a policy, it's all going to show up in a search history to show the interconnectedness. So it's not only the number. Direct hyperlink at the end of a policy language that says, now jump from this policy to this administrative regulation. That's not something in the platform that we currently use provides. We've had one or two clients inquire about it. Overall, the feeling has been that because the interface is so user-friendly and so clear and the search engine so robust, which is the main reason we went with this third party, was that it wasn't necessary. And so I know that requires a little bit of faith, having not seen it, but I will tell you that navigation of it really is quite simple. Infinitely easier than what was previously on the district's website, and much more easy to navigate than the current PDF, scroll through a PDF format. And so the connectedness of those things, I think, will be evident to anybody who's able to engage with the interface once we're done with the process.
Okay, so that information helps. So you're really saying the reason we're not doing it is because right now it's just a system limitation. And again, it seems like a fair point, but I just want to make sure that's what I understood, is really, if by trying to add that language there, it doesn't interface right now with what would be forward-facing.
I think that's fair, and I'll publicly and readily admit I'm not the tech guy.
That makes sense. That
Yeah,
makes sense.
I mean, I can connect my Bluetooth to my car, but that's about it. But yes, I understand it to be a system limitation, but because everything is indexed down the side, you can expand administrative regulations. So for example, if you're on 2003, you can expand AR 2003 and see what it is and hyperlink directly to it there. You just can't do it from the end of the text in 2003, but you can do it down the navigation, down the left-hand side of the interface.
Or you could also search 2003, and they'd both pop up.
And candidly, when we went through the process of vetting companies that could handle these interfaces, the one we went with was the one that had the most robust search engine. Most people are not going to sit down and go to a website and type in, what is the Title IX policy? They're going to type in a word like harassment or discrimination or whatever, and we wanted to make sure that they got all of the hits that would come up. This company specializes in codifying local ordinances, and so they have a very robust search engine, which is why we've used them, and between the ARs, administrative regulations, and the policies, it is really quite easy to navigate. But I appreciate the question and the clarity, because I think it's important. We take for granted that everyone has seen it like we have and how easy it is to navigate, so I appreciate the search for clarity on that topic.
Okay. Trustee Annis, I believe you had something else in 2003?
Yeah, in red, the addition of child find. Specifically, I had a constituent email me regarding this because there's no notes next to the text, whether or not this was an addition or an update. And I believe that it's both. Is that correct?
Yes, that's correct.
Okay. And so even though I think it, and I looked back in our prior policies, which this fell under, which is specifically ADA and 504 compliance. So this just kind of gives more detail about what that is,
Yeah,
correct?
it's a great question, and I appreciate the question. And so let's provide some context for where we get updates from, because it is an update that we provided. Where do we get updates from? And they come from a few different places. When the folks in Lansing get busy, very often there's things that we need to respond with from a policy standpoint. If there are seminal court cases that come down, very often there are times that we need to respond with policy language. Those are two of the primary avenues. The third avenue is a byproduct of what we see every day in the field. We have the great privilege of working with a number of districts all around the state, and you see trends start to emerge. So what we noticed as a team was that there was an uptick in the number of U.S. Department of Education OCR complaints that were being filed that were critical of the absence of specific child find language in policy, okay? Now, one way to look at that and say is, well, isn't that just saying we're going to follow 504 and the IDEA? Were we not following those things before this language? No, of course we were. Absolutely we were, which is why a lot of places didn't have specific policy on it, because it's under the IDEA and 504, and we're going to follow those things with fidelity, even in the absence of a specific policy. But when we start to see a trend emerge, it's not like anyone came in and said, you better have a child find policy. But once we get into looking at a second or a third complaint come into OCR, that's examining an area like that, or asking questions, or saying, well, you had it in this place, but you didn't have it in this place. That's a primary avenue for us to say, let's craft an update, let's craft a policy, and that's really where the child find language comes from. It's meant to fill that gap, make sure that there's no question or ambiguity or uncertainty about it, but rest assured that obviously the district is, whether we have a policy or not, required to comply with IDEA and 504, and I assume was doing so with fidelity and diligence. This is simply to plug what one may perceive as a whole.
Thank you.
All right, are we ready to move on to 2004? Yes, we're an hour and 10 minutes in.
Again, I don't think 2004 reflects any changes. 2005 reflects some changes.
So wait, if it doesn't reflect any changes, we're just not talking about them? We're not allowed to talk about them?
No,
No,
if you have
I-
a question, no one raised their hand to be recognized.
You just started talking. I just wanted to make sure. We went from 2004 to 2005? Okay.
So trustee Weaver, do you have a question on 2004?
So 2004, so we have had some parents raise concerns around the student-initiated clubs and having, again, here we have it just called out, the rules will be set, where is it? School district premises, subject to such rules and regulations may be established by the board, superintendent, and district. So that feels like, shouldn't we be calling out what those rules are? Shouldn't we make those rules clear in this policy? Since, again, it does state the boards can set those rules. And again, I mean, let's identify, this falls right along the lines of the controversial material policy. There's obviously a lot of issues that are hotbed issues and political. So again, wouldn't it be clearer for us to just call out those rules right here in the policy versus saying there's some rules, but not really letting anyone know what the rules are?
Yeah, so I guess a couple of thoughts in response to that question. First of all, the part of the reason, and I'm glad I wasn't intending to go too fast, and if there's questions along the way, I obviously want everyone to have an opportunity to have those answered. What I was trying to gather very quickly was, in the absence of any color, suggests to me, and I'm on a cross-reference our original audited version, that this is existing policy. That is what you have. Now, it might not be in this place, it might be moved around, but it's existing language that is what you have, and that's why I suggested that there had been no recommended changes to it. Specific to student-initiated clubs, you'll see in that language there's a link to the Equal Access Act. And the Equal Access Act is a federal act that talks about the ability of students to create their own clubs, have different things that they're interested in, and there's some parameters around that, and there's a whole lot of interpretive case law around the idea of equal access and student-initiated clubs. Student-initiated clubs are not the same as school-sponsored clubs or clubs for which there's a faculty advisor or things along those lines. And so the bullet points that you see there under are really intended to comply with the Equal Access Act and the case law that interprets it. That's specific to that. To the extent that your question is, well, can we beef it up to talk about other things? Again, those are certainly within the realm of the board's authority to do. There were no such suggestions in the policy committee that were advanced, none that I recall us having any discussion about, and so that's why you see a manual in front of you that has reflected no changes to that language. I don't know, Trustee Weaver, if that was responsive to the question, but I tried.
Sure, somewhat responsive. And again, that's no fault of yours. There really wasn't a defined process on how we could submit stuff or how we could go after this. So again, as we talked about before, we didn't even know when the process really started. So that's not on you guys at all. My concern around all of it, and again, you constantly me, I would rather see us over-communicate. So even what you described is why aren't we calling out more clearly exactly how these clubs can be created, what they follow, instead of just providing a link, why don't we over-communicate, clean up some of the language, and so have the clear bullet points of what are the actual requirements, so it's clear when someone says, hey, what is a student-initiated club, what's the policy, they can look here and just have a real understanding of what that is and what rules they follow. again, my question would be, what would be the harm in doing more of that versus what we have here?
Yeah, a couple of thoughts, and again, I appreciate the question. Harm, I don't see particular harm. I guess two things. One, you talked about the absence of a clearly defined process. I've had so many color-coded versions laying around. At one point, I had presented to the committee, depending on who had made a suggestion, whether they had submitted it in an email or an attachment, everybody had a color. And so the three different trustees had their own color in terms of, in addition to the red and the blue, about what suggestions that they had made to edit the policies. And so there was a meaningful opportunity for every committee member to make suggestions.
Mr. Sutton, real quick, I'm not going to interrupt you, but I'm not, that question or that comment was not directed at you, because even to what you're saying, obviously it was about the committee, the whole board. So to that point, I wasn't on the committee, so there was no firm process for us. So that's not a shout.
No, and again, I don't take it that way, and I appreciate the clarity, but I look, if we're going to go through the exercise of having the discussion and we're talking about the community being aware, I'm happy to give a little bit of additional context, because mercifully for most people in this room, they didn't have to sit through all the policy committee meetings. And so I'm happy to provide context for what we did, though I appreciate the overture. I guess the other thing that I would say is this, because I'm sensing a theme of, would it hurt to add more? What about this? And I think those are all fair and reasonable questions to ask. This is going to be my analogy that I'm going to use. Most people in this room are probably homeowners, right? And we all probably remember the first house that we bought. If you were super lucky, it was perfect. Most of us, our first house was not. We were lucky to get in, and we were lucky to own it, and we were excited. And there was a whole laundry list of things that we wanted to do, right? We wanted to rip out the cabinets. We wanted to buy a new couch. I remember the list like it was yesterday, okay? Where we're at in this process is we've got a house that we were trying to get in, and we're trying to make sure that it's livable. That doesn't mean that we're done. That doesn't mean that once we get it livable and we can finally move the boxes in, that we're stuck with those ugly cabinets and that nasty carpet for the rest of our lives. I think what we're trying to do with this process, and this has been my mindset, and maybe that's not the best analogy, was let's get us moved into the house. Because right now, when we came to this process, we had a house that was boarded up and not prepared for it to be inhabited. Now we're trying to get into the house. And just like I had a honey-do list and a laundry list of things we wanted to do, we'll buy new furniture and we'll add carpet and we'll put up new wallpaper and fresh paint as we move along. And I think those are all good suggestions with which I have no personal objection or professional objection to considering those things if that ultimately is the will of the board. But I think what we're trying to do is we're trying to get into that house, because frankly, the house was not in order and we're trying to get in. And so that maybe is a grossly unsatisfying explanation of what my mindset is on this, but I think that's what we're trying to do here now.
So actually, Mr. Sutton, I'll say no, that's absolutely very much a great analogy, and I really appreciate it, because I think that is what people are missing. And for us that haven't been involved in the conversation, we don't understand the scope of what the scope of this project was. Again, as we started, we don't know when it started, what the end goal is. So really, you're saying the scope of this project was, we started with the mess that we had. This is just to get us to having something. Because that's what I took your analogy, that really made sense. Just get into the house. We have the structure, we have the bones in place, and then we can move forward as far as adding stuff to it. But this is really, like how I'm hearing what you're saying, this is let's just get to the bare minimum, get cleaned up, get the structure in place, and then start moving forward.
Well, I wouldn't say necessarily a bare minimum. You move into the house, you got to have a certificate of occupancy, you got to have heat, you got to have water, you got to have all those things, right, to move in. And so to be clear, and I'm not, we had an interface through the district website that was not particularly accessible. We had certain policies that had not been updated, or at least reflected that they had not been updated in some period of time. The history of that, how that happened, what the communications were, who was supposed to carry updates from point A to point B, unclear. So I want to be really clear. I'm not saying that this is bare bones, this is just to have something in place. We would not advance a manual, and I would not have asked the policy committee to advance a manual that we did not believe put the district on solid operational footing. That having been said, I'm not going to sit here with a degree of personal hubris and say it can't possibly be improved. Because it should be a living document. I hope that the Rochester Schools is going to operate after today. I think everyone in the room hopes that's the case, right? And so I'm not going to be so arrogant as to say it's perfect and you don't need to look at it again until the next time in 5 years you want to do an audit. Of course not. And so that's what I mean about let's get into the house. And then if there are things, new drapes, new faucet, I think we can do those things. but we would not advance a manual that we didn't feel gave the district solid legal and operational footing to move forward and then put it in a format that people can access so they can see the policies, they can see the administrative regulations, and be able to tie those things together and understand what's going on with their district. And so, again, maybe not the perfect analogy, but I want to make sure I provide the appropriate context and clarity for it.
Nope, I appreciate it. Actually, I think it's very good. I think semantically we're just saying a few things differently, but I think we're on very much the same page. Appreciate it. Thank you.
Okay, anything else in 2004? Okay, 2005?
So 2005 talks about communication, and there were a couple of minor tweaks on distribution and posting of materials to your existing language. A lot of it was just grammatical in nature, and then making sure that smoking was inclusive of vaping and marijuana. I think the chief discussion we had within the SPCC, and I would defer to the members if they have any comments on this, was around what a closed forum is and making sure that we clarify, provide some additional context within that language. And so that's the red line edit you see in the closed forum language. And as I recall, we made note of the fact that closed forum, public forum, limited public forum is, 2 semesters of law school and trying to understand what that all means and all of the case law around it. But the ability of the district to control the communication within its forum is the key takeaway. And again, I think to some of the point that Trustee Weaver's been making this evening, to try to provide some additional context for what that means. And so you see that red change in the closed forum language to provide some examples and some additional clarity there.
So I'll ask my question. So again, going back to where we started, so with this specific added verbiage, what does it tell us we can or cannot do? What is it actually directing us that we can or cannot do? How do I violate it? How does someone violate it?
Speaking specifically to which, 2005 in general, or any of
The closed forum
the closed
specifically,
forum?
because I think that's where I heard most of the discussion revolved around how the closed forum's interpreted or how it actually is real-world impact.
So the closed forum is when properly designated and implemented. And I will recognize and acknowledge that sometimes implementation is not consistent with what is a closed forum. And so there's some fact-based nuance to that when we deal with First Amendment issues. But by designating the district as a closed forum, what we're saying is that we are not open for people to walk down the street and use our facilities for whatever speech they'd like. And that the district is going to, and has the authority to regulate that speech to the extent possible within its doors. Now, that does not mean that it has unfettered authority to regulate every component of speech, but it does mean that we're not opening ourselves to the public for the public, those that are outside of our walls, to come on campus and exercise authority. So the example that I'll provide is that if we opened up to some kind of limited public forum and let's just say Nazis wanted to use our facilities, we would have less authority to regulate that than if we designate as a closed forum.
So I think you see in the clarifying language, for example, communication which is obscene, vulgar, otherwise violates school district policies and/or the student code of conduct. Now, you could say, well, what does obscene mean? What does vulgar mean? And you could drill down very specifically on those definitions. I would say that there's an art form to crafting policy language. Not to give too much credit to policy drafters, but there is a bit of an art form to it, because from an operational day-to-day standpoint, there needs to be a degree of latitude provided to administration to make decisions based on what they're confronted with. If you overly define terms, that limits that latitude. And so that's why you see terms that, yes, obscene, vulgar, are subject to interpretation. But I think that degree of flexibility is necessary for effective administrative operation.
I have a follow-up question, but if someone else has one.
Go ahead.
So to the way you described it, the outside people coming in, but specifically in it, it says, district reserves the right to prohibit communication by students. So this gets right into the students part, which later in this document, we're going to see a political activism where we say basically students can say whatever they want. So here it seems like we're being real wishy-washy on how we want to look at the First Amendment when we're picking and choosing when we're going to contradict ourselves. So I think to your guys' point, 100%, I think we should be basing our standards, like fire is a great institution as far as really defining what is free speech and trying to craft that policy. But to me, this one, again, it's not clear on what it is. Even as we sit here and talk, is it outside people coming in? Because I think everyone would agree with that. If this just says, hey, by deeming ourselves a closed, if any group wants to walk in off the street and have a protest, we can kick them out. I think everyone would go, yeah, we'll sign up for that. But that's not what I'm reading in this policy when it specifically says that when it specifically prohibit communication by students. This does fall down the part of where we're seeing, again, in the political environment we are, that it could be certain speech might be deemed vulgar, and that's where the subjectivity comes in. If it's an opinion someone doesn't like, will they be in violation of this? But if it's an opinion that falls under the political protest one, then it's okay. I think that's where we're going to run into potentially risk of true First Amendment violations, and we're going to have contradicting policies within this document.
Can I speak to that? Because the work that we did in the committee specifically in calling out what is obscene, vulgar, but specifically including the student code of conduct, because it is something that every student is aware of. They should know what the expectations are. So if it's deemed that that falls under the student code of conduct, there is your definition of what that behavior could result in.
But there's also the word vulgar there. And so anyone can decide what vulgar is, and I don't have to go to the next step. I mean, that's how policy works. It's an either or. It's not, you have to be all of these things.
So I would share, those words are legal terms of art. They have, and again, Mr. Sutton mentioned the 2 semesters worth of case law that exists as it relates to those things. Ultimately, and I'll say this outright, viewpoint discrimination is unlawful even if you have a closed forum. So to the extent that someone's discriminating based on viewpoint, that's a problem and is unlawful. And I would encourage and discourage anyone from engaging in any viewpoint discrimination because, again, it's unlawful. And that's our role as attorneys to say, you can't do that. As it relates to this particular policy, the reason that it's our recommendation, because we've gone rounds with clients that want to open up the public forum, is because it offers the district the most authority to regulate its premises and the most authority to make those decisions. Now, ultimately, Rochester and its administrators and its board can make individualized and nuanced decisions about what it wants to do, but our recommendation is going to continue to be to have a closed forum because it offers the most latitude in terms of the regulation that we can implement with students or others.
And again, I'm going to say, I think I agree with your premise of closed forum. I'm saying this isn't clear on what a closed forum actually looks like in real world application. So to that point, we're going to go back to, if there's an administration regulation or something that feeds up to this, how do we know that it's meeting that standard? Or how do we know that we're actually, as a district, not doing those things? Because to your point, the whole point of the policy, the violation would be here is if we are actually having viewpoint discrimination or we're actually violating that. So that's, again, where I'm saying there just isn't enough detail here to call that out so that we know whether we're actually giving a document to our building staffs to say, hey, look, here's the rules, here's how you determine it, here's the standard, which, again, goes back to, with the premise of starting with, yes, we want to be a closed forum that makes complete control. If it says, hey, I can just make sure that no protesters coming off the street and agitate our students, absolutely, all day long. But that's not clear in this policy.
So I guess the thought I would express is you're talking about prescription, and I'm sensing a theme of prescription and detail and prescription. And there are a lot of boards, there are a lot of individual board members who find comfort in prescription, that more is better. The more policies we have, the more language we have, the safer we are, the more clear things will be. There's a flip side to that. And the flip side to that is when you have gotten very prescriptive and you've tried to foreclose every single possibility and every single scenario that might come up, the scenario that's going to come up is the one that's not addressed in the prescription. That is inevitably how it works. And I'll Mr. Silveri's been doing this a long time, I'm sure he can verify that the situation, if you're very prescriptive, the situation that often is the one that's going to come up is the one that the prescription doesn't address. And if you're that prescriptive and it doesn't address it, does that mean that you don't have the policy authority to deal with it? As opposed to something which is slightly more scaled back. Now, you made the comment earlier that there are different philosophies to drafting. I think this probably falls into that bucket. This is a different philosophy on drafting. Our philosophy is not to give you 7.5 pages on every single policy when we think 3 sentences will do. There are those who will say, give me the 7.5 pages. There's comfort with 7.5 pages. 7.5 pages makes me feel warm at night. That's fine. That's a choice. That's a choice that the board gets to make as a group. Our approach is to not bring a sledgehammer to kill a fly. That's our approach.
Trustee Blake?
So I've been trying not to say anything because I've been in, 30 hours or so of meetings on this, so I wanted to let other people speak. But first thing I want to just make clear is every word that is, so for instance, in this policy, every single word we went back and forth on. I mean, this was probably 45 minutes on this particular one, and we all ended up agreeing. And I do think your last comment, Mr. Sutton, was really, it was really true. This is a philosophical thing. I think Trustee Weaver seems to want a policy that's like a math equation. You take a fact pattern, you drop it in, and it spits out, and there's no subjectivity, and there's no room for any evaluation. And I just don't think that works when you're talking about people, when you're talking about kids, when you're talking about all manner of fact. We can try our best to put principles in place that tell us how we make decisions. And that's what you do in the law a lot of times. There's no math equation that's going to cover all of this. And we're never, ever, ever going to get through this if we look for a math equation on every one of these.
Trustee LeCouey?
I'm a member of the SPCC too, and I was talking about this one and debating it quite a bit. When I was looking at the closed forum language, it was before we had the red text that talks about examples of this communication. And I understand Trustee Weaver's concern about viewpoint discrimination, and that was something that I brought to mind, and I was very concerned about it. One way that I felt more comfortable with that was actually when we were able to put an example, and I remember suggesting some of this language. I was looking back at the social media policy, which I had some issues with, and some of the language on here, like off-topic or personal attacks, seemed subjective to me, and I still have issues with that. But other language in here, like obscene or vulgar, I felt it gave a better idea of what we were trying to go for. So I'm only saying that just to say I thought that the language in red was a decent compromise that helped me feel more comfortable with it, because I did feel like I had a better picture of what it was that we were talking about that went against the code of conduct, rather than it being a concern about viewpoint discrimination.
So, one, I'm going to clarify some stuff, because no, in no way am I suggesting that there's a math equation. I don't know how anyone can conclude that. And Mr. Sutton, I would say that I think there's also somewhere between a few sentences and 7 pages. There's nuance to this. So what I'm saying is I think the policies need to clearly state what is the intended goal and have a clear outline of how do we know if we're meeting it or not meeting it. So if a few words are necessary, and actually I'm a big believer of the ideas that we should try to use as few words as possible to convey a clear message. Again, cut out the fluff, just get directly to the point. So this one specifically, again, I just go back to, it's unclear what it means by prohibit communication by students. How do we prohibit? What is someone allowed to do? What is someone not allowed to do from a prohibit? Because again, I go back to, we're going to have a counter policy that is around social activism. And so now, can I refer back to, if I'm an employee of the district, can I refer back to is I can prohibit that, because this one says I can't because I'm a closed forum. How do we, it's just a logical process, not a math equation, a process of what is the standard. And to the point, in no way, you're right. Policies have to be written actually broad with the clear goal of what they're trying to attend. And then that's why when the process is being followed and you realize, oh, we didn't account for this, that's continuous improvement, corrective action, you readjust your policy. So no, in no way is this a math problem, but yeah, this is just not clear of what the standard is, how we would know as a district if we are doing this or not doing this, and if we're executing it properly.
So what I heard was prohibit communication by students is unclear, and it doesn't say what you can and can't do, I think is what I heard. I don't think the phrase prohibit communication by students is vague, ambiguous, or otherwise confusing. I think the thing, and again, this is a systems question, and I appreciate the dialogue, and I appreciate the inquiry about it. This is not the whole story. This is the policy. This is not the whole story. Halftime a couple weeks ago, when Usher was dancing around, he asked most people, they would have said, man, that was a boring half of football. The first half was not particularly exciting. It was 30 minutes, it was 2 quarters, all right? Second half had a lot more to it. There was a lot of action, a lot of things going on, a lot of touchdowns, ball up and down the field. There's 2 halves. There's 2 halves to the governance model. So yes, policy is part of it. There's going to be administrative regulations, and we've talked about operational effect, we've talked about those things that are going to be the second half of this governance model. And there can be respectful disagreements about whether or not it should all be policy or some should be regs. That's fine. It's a drafting philosophy, and I've made it really clear what our drafting philosophy on it is. But I don't want you to think that in every situation where you see a short, succinct, to-the-point policy, less is more, you said you're a fan of, that doesn't mean that that is the one and only final word, that there very well may be an administrative regulation that goes with it. If there's a suggestion from the board, once the administrative regulations are developed, hey, John, I noticed there's not an administrative regulation on this topic. I think it would be helpful if we had one. Okay, superintendent can take that under advisement and perhaps add an administrative regulation. Maybe he'll say, you know what, I think that might be a great policy. Maybe the SPCC should talk about that and come back to the table and suggest a policy. And so I hear what you're saying, Trustee Weaver, I do. I want you to know that I'm listening intently and I'm hearing what you're saying. But this is not it. There's going to be more to it. And the administrative, because a lot of what you're talking is the prescription. It's what I call the X's and O's, the blocking and tackling. And I apologize for the sports analogies. It's who I am. But a lot of what we're talking about is that blocking and tackling. The board sets the expectation. Administration go do the blocking and tackling. And oh, by the way, show us the playbook. Show us the X's and O's so we can make sure that the plays that you're going to run comport with what we think the game plan should be. And so I think in a lot of these instances, and again, I appreciate very much the questions and the dialogue, you're asking about the blocking and tackling and the X's and O's, and we're going to get to that. But we have very intentionally not done it yet because we didn't want to assume we should write a bunch of plays and have a playbook until we heard what the board wanted the game plan to be. And so, again, that may be, again, another grossly unsatisfying answer, but that's the paradigm that I think we're struggling with as we come close to the 2-hour mark and we're still in the 2000 section. That paradigm is not going to go away through the rest of this discussion because we draft with a philosophy. And I'm not saying that we're right and everyone else is wrong. I'm not saying that we're perfect and there's not room for suggestions. That's not what I intend to say here at all. But we're either going to have to continue to debate that paradigm for the next 14 hours, or we're going to have to accept that this is what it is and this is what the process is going to look like and start having substantive discussions about the additions that are being made. And I mean that in the most respectful way because I do think it's important not only for the full board to understand what the SPCC has discussed, certainly for the community to understand it, but it's drafted as it's drafted.
Trustee Gupta?
I'd just like to say that, given the fact that this process we've known as a board has been ongoing for the last almost year or so, and that we've had this draft, each of us, for a little while now to review, and that we came to this meeting with the intention of being able to reach consensus on the outstanding parking lot issues and discuss and ask questions about things we weren't sure about, that if anyone has multiple substantive alternative proposals, those should have been provided ahead of this meeting to the board to consider so that we would have that at our disposal at this time when we're having this timely discussion to factor into our decisions. And if at this time you're going to propose and combat and debate every little thing, at least at a minimum, propose some alternative language that you'd like to have adopted instead of what's here, so that we can consider that. Otherwise, we're just continuously stuck in this circular thing that's getting us nowhere.
I've learned a lot tonight. I think the board's doing the board's work at a work session. I don't know. That seems a little odd to me. But anyways, I'll just say, to your point, Mr. Sutton, what you're describing, though, is still goes back to what you talked about earlier. You're asking the board to put a lot of faith in this. So even minimally, I think where if through your process and your philosophy, then it should be at least kind of bullet pointed out where we would expect to see an administration regulation. That way, again, from a board standpoint, if we're going to say this is the process, we could go back and say, okay, when this is done, we expect to see 10 administration regulations come out of it, 50, whatever the quantifiable is, to then go back and say to our team, here they are, what's the plan to get these all done? But even at that, even the way you just described it, it's very much just trust us, there's a second half, and we'll come back. I think that's a lot, you're asking for a lot of faith from a board and a community that has ample reasons to not have that faith and not have that trust. So I just think we have to acknowledge that as we're working through this process.
Was that one meant as a personal attack or no?
No, not
Oh,
towards
okay.
you.
All right, okay. So here's what I would say, and I've been in bed for 4 days. It's been a long day already, but I appreciate the dialogue, and I appreciate Trustee Weaver saying that he's learned something about this process. Policy work is hard. It's hard work. There's a lot to it. And so while I'm tired, I'm sure other board members are tired, I do appreciate the discussion, and I appreciate the questions that you've asked. And I hope that in the time we've spent talking about it, there is a improved sense of understanding of what this all looks like, the effort that goes into it by committee members, and the balancing act that gets done to a certain extent. I think I'm not asking necessarily for blind faith. What I'm asking for, and part of the reason why I provided the cover memo to the board, and part of the reason why I opened by talking about the color coding is this. We were surprised to find, and I communicated this to the board, that once we distilled the mess that was the website, and we distilled it into a PDF, and we started looking at it in the right order, and what I mean by the right order is the way it was intended to be presented. There's not that many changes in here from what you have already. This thing is not dripping with red. This thing is not dripping with blue. There's a whole lot of language and a whole lot of sections that haven't been touched, that are what you have. And so, pardon me, when you're saying, you're asking for faith, you're asking for this, I'm asking you to look at the work that this board has done, because a lot of the work that this board has done is still what is reflected in here. If I was handing you a draft manual that every page was bleeding red, I don't think I could say that. But honestly, you'll flip through and there's pages where there's no red. There's pages where there's a little bit of red. And again, as I highlighted, there's only about 4 or 5 blue sections that the SPCC couldn't come to a consensus on. And so I appreciate the question, I appreciate the dynamic, and I wish I had a panacea for the problem. But the only way to solve that would be to do the regulations while we're doing the policies, and I think that disenfranchises the board's efforts, and I don't want to do that. What I can tell you is that the baseline administrative regulation manual that we use, because we don't just walk in and say, what do you guys think, administrative regulations? We come in with something to work off of, okay? We like this one, we don't like this one, we need to add this one, okay, here's a form, we love this opt-out form, let's add it. Our baseline administrative regulation manual, I think, is something in the neighborhood of 65 pages. So it's bigger than the policy manual. So a lot of the blocking and tackling, a lot of that X's and O's is going to be there. You referenced at the outset the email that's posted on your Facebook page, and I was really clear in that email that Rochester took a really unique approach to this out the gate. It's not an approach that I love. I wasn't involved with it. It's not an approach that I particularly loved, but it's what we've got. And so we're trying to, I don't want to use the phrase, get this thing back on the tracks, but I think we're trying to get back to a position where we have full confidence that we've got a policy manual that is giving us what we need. Can certainly be improved, and then let's drill down on those administrative regulations so that prescription is there. And I will tell you, Trustee Weaver, that in a number of districts, when it gets to the point where we're done, I will have administration say to me, well, let's just post the policies. Let's not post the administrative regulations. Kevin, what do you think about that? And every single time I will tell them, you should post both. Because for a lot of districts, this is a paradigm shift. They're used to one sort of brand of policy drafting. This is a slightly different approach to that. Let's put everything out there. Let's put the policies. Let's put the administrative regulations. Let's have them lined up by number, as Adam referenced. Let's have a robust search engine so you can type in the word speech and you're going to get 15 hits. And let's have all that information out there transparently. They're just, it's like driving to Florida, man. You got to stay on 75 for a while to get there, and that's the reality of it. And that's where we're at with this. But again, I appreciate the dialogue, and I appreciate the opportunity to provide some context for what we're trying to do. But again, I hope no one looked at this manual and said, my goodness, this thing's dripping with red, because it's not. A lot of it is what you have, but it needed to be moved. It needed to be updated. It needed to have the right stuff around it, and it needed to be put into a position so we can draft effective administrative regulations to address things like the new Title IX rules and whatnot. So I'm probably getting long-winded because I'm getting tired, so I apologize.
Trustee Lakouи?
All right, well, I've had a long time to sit and stare at this page, and I was wondering, when it comes to the distribution and posting of materials policy here, who is this one directed toward? And when you say unless the materials are generated by the school district itself, I was curious, are you referring to central office or are you referring to all of the buildings within the school district?
So it's really intended to, again, we've talked a little bit about forums and things like that, it's intended to prevent kid number 6 or staff member number 7 from distributing a bunch of paper for no reason, right? Ultimately, materials that are created by the district are going to be excluded from that, obviously. And then there is associated, and you'll see there is actually an AR reference in this particular one from Mr. Weaver, is that there's some prohibitions about what those things can be, or what things can be posted or distributed. And so again, I'm also getting tired, so I'll apologize. Did I answer your question?
Well, I guess I was asking also, when you say generated by the school district itself, do you mean central office? Do you mean all of the different buildings within the school district?
That means everyone within the school district. So if a building is going to do flyers to take home, that would be excluded from the prohibition or the approval process, I should say.
Well, that makes sense to me, but I wonder if,
I apologize. I need to
Any
take a
of the
break
members
for a
of the school
moment.
district?
If Adam, you're good with Adam here for a few minutes, I just need to step away for a moment. Thanks.
I was hoping to get through this section so that we could take a break, but yes, please go ahead. Trustee Lakoui, did you have a follow-up on that? Were you?
I guess I'm just wondering if there's a way to just be clear about that, because sometimes I know our district, when you say school district, we're referring to central office, and other times we're referring to maybe any employee of the school district. So unless materials are generated by any employee of the school district, perhaps, I don't know, I'm just questioning that now. This is not something I thought about before. I was just literally staring at this, so. I just don't know if it's clear.
I can think of one example where I've seen a policy like this being used, where we had a nice parent that everyone really loved, but this person had their own business. So they had this great idea about advertising. So they brought in all of these flyers for the teacher.
Right, yes, and I'm
Yeah.
not talking about parents. I guess I'm thinking more along the lines of teachers. Does this apply to teachers too, or just administrators who might
Well-
work in central office?
But it says all posting materials require prior written approval of the building administrator or his or her designee.
So functionally, the concept is that anything from outside the organization is going to require some kind of approval from the building administrator. Things that are going to be internal are functionally going to be dealt with either through the personnel policies or the specific directives that are generated by the building administrators or central office. So that's something that, again, we talk X's and O's and blocking versus like the broad goal. When we talk about specific district employees, like the superintendent and our administrative team are going to delegate authority to do some of these things because it's just good for kids, right? We're not going to prohibit a teacher from distributing materials to their students and their parents because that would make no sense, even if we do have the authority to do so, right?
But this
So-
would
So
allow us to do so
this
if we
would
wanted
al-
to.
this- So HR director by trade is that ultimately in an employment relationship, the district's going to exercise a lot of authority over its employees and be able to prohibit or prescribe any number of activities. I would discourage the district from trying to adopt a policy that gets too into the specifics of that, because functionally, the reality is that there are, how many employees in Rochester Community Schools? A couple, quite a few. And so the reality is that there's no policy that you can ever generate that's going to cover all of those concepts. And so ultimately, we trust our administrative team and we hold our administrative team accountable to the policy. And we make sure that if there are things that are going on that violate those policies, we hold our staff accountable to those things as well.
I guess that part confuses me a little bit. Where's the premise come from? Because of the number of employees, we can't have a district standard for all employees. Again, I come from the manufacturing world. Plants are huge with lots of employees. We all have set standards. Even from plant to plant, standards are the same, especially around distributing material, like what we can distribute, what standards there are. So I guess I'm just trying to understand where that idea comes from, that a district policy couldn't be standard across the district, so that if I'm a teacher in one building and I get transferred to another building, should the standard on high-level items, not the details in the room, high level, what certain things are, why would they not be standard at the district level?
Well, I think they absolutely would be standard.
Okay.
And so I guess my question is, what suggested policy would you like to standardize? Or what type of language would you like to standardize?
Well, I'm sure we'll get through a few, but I'm just saying specifically to the question that was asked right here, and I'm responding to what you said, and there was this implication that because there's 100 employees, that there couldn't be a standard. That's what I thought I heard.
Oh,
If
no,
you're
no,
saying
no.
that's not what you said.
No, I apologize if I was unclear. That was not my intention.
Okay.
What I'm saying is that ultimately, as we talk about policy and we talk about enforcement of policy as it relates to our staff, many times that's done through the evaluation mechanism, and sometimes it's done through the mechanism of a principal seeing something that's inappropriate or improper, and they're going to deal with that. And so as a policy statement, I discourage boards from trying to get too into the weeds on what's going on, because we hire good people, we put good administrators in place to oversee our teaching staff, and we trust them to do a good job as it relates to things that keep kids safe and do what's right for them instructionally. And so from a policy statement, I absolutely would say, we're going to do what's best for kids. We're going to make sure that we have the authority to regulate things as we need to. And then we trust our administrative team to do just that. And if they aren't doing that, that's when we hold them accountable.
Okay, so the premise of trust, I get what you're saying, but there's another way to look at that. We also owe our teachers, we owe our building staff the broad guidelines, because again, the other word you just put out there was to hold them accountable. So if we don't have the broad standards in place that say, hey, here are the broad guidelines, here's what the rules you have to stay in, and then you empower them to stay within those broad guidelines, then we actually aren't, we aren't providing our obligation to them. So again, it's just two different ways to look at it. So this idea that we simplify every policy, and yeah, you're going to hear everything. Every policy we should be able to look at clearly and say, what is the intended goal? How do we know we achieved it? And how does someone know whether they violated it or didn't violate it? And in this case, based on your guys' philosophy, it would be, how do we as the board look to see if there's an administration regulation or a process that will achieve this? Again, that's a different philosophy, but to that point, in some of these as we've gone through, and yes, that's why it's taking time, because Mr. Sutton, again, wanted to wait till you got back to say this, is you're right. Because it was such a mess before, no one could actually look through these. So to say that some of these, that's why there's some of them that are black, when you finally could see it in an order that made sense, yeah, there's new questions are popping up because they just hadn't been reviewed since apparently 2020. So that is fundamentally, I think as we keep going through this, we're going to see that piece of, is it just clear, and are we actually giving our employees what they need to make sure that it, to me, the expectations or the standard, which is what the district policy should be to me, is the standard is in place so that they really know, to the point, am I protected from that standpoint? Because I think the other part of all these policies are, we really do have it go both ways. Everyone wants to act like, again, you hear parents' rights, parents' rights, parents' rights, but it's also about parents' responsibility. Are we protecting our employees to say, hey, no, here is the policy, our people did it correctly, and guess what, parents, you can go sit down too. And so that is, again, a way to look at the policy both ways. Yes, we want to, one, build policy that regains trust with our parents, but also do protect specifically our teachers. And to me, I think that's really at the heart of some of these questions, is that clear? And to the point, going back to where we started, with this first one, we're going to see we have contradictory policies around the First Amendment. I can see now, again, if I'm a teacher, not really sure what I can and can't do, and
So
I
Trustee
might get
Weaver-
myself in trouble.
Trustee Weaver, I guess I'm just asking, are you talking about, because there's 7 bullet points there of what you cannot post, right, as well as referencing an administrative regulation. So are you referencing to know what they can do or something else?
So I was referring back more to the closed forum one.
Oh, you're back on the close.
I mean, they both
Okay.
kind of go together. I mean, again, I think we're going to see systemically throughout this whole
Okay,
pack.
but we went back to, we have a philosophical difference there on that. I had a question where it does reference the accounts receivable, administrative regulations. Is it possible, because I think that's referencing the old administrative regulation number, right? Because any new administrative regulation would be a 2005 point something, right? So one, if we're not ready to move it yet, so that we don't have to come back and change policy language, can we just say violates administrative regulations or otherwise, blah, blah, blah?
Yeah, I think that's fair. We've highlighted that. We've highlighted that as something that we needed to address. I think violates any administrative regulation or otherwise would be appropriate language to have. And then if we want to come back once the administrative regulations are done and add numbers, we can certainly do that.
Okay, thanks. All right, does anyone else have anything under 2005? Otherwise, I'd like to call for like a 5-6 minute break here. Okay, so we will take a 5-6 minute recess here, if everyone could move quickly, and then come back so we can try and get through some more of this. Thank you. All right, if we could come back.
I'm looking at his tech. Oh, you gotta send me that link, and it's only 75.
All right, Mr. Sutton, if we would like to continue with, I think, 2006?
I believe we're on 2006, that's correct, and the first noted change are some updates to the attendance and truancy policy, and then the addition of a student appearance policy. I think one of the things we talked about in the committee was that student appearance is also generally addressed in the student code of conduct as well. And so those are the main changes that you see in the first couple of pages until we get down to the personal electronic devices section later in 2006. But I'll pause there to see if there's any questions or concerns.
I just had one, and I know there was no change to it, but on the long-term suspension and expulsion piece, isn't there a requirement to have an appeal process, and that is made up of board members along with other committee members?
A legal requirement?
Yeah,
No.
no, not at all. So you don't have to have the superintendent, in this regard, the superintendent makes the decision, and there's no recourse for an appeal?
Correct.
Would we be able to add an appeals process?
Yes.
Which I know we have done, so that's why I'm curious based on this.
I think there are limited instances, I'm going completely from memory here, because the district has steps, as I recall, in the student code of conduct. I think there are very narrow circumstances under step 8 where there may be an appeal. I can't think of an instance in which the district has utilized them in recent history, but yeah, it's possible that provision is in the student code of conduct. It's not what's in existing policy.
I guess I'd like to see that incorporated if it's in the student code of conduct to,
So in other words, under long-term suspensions and expulsions, and again, I'll have to pull the language, I believe it's step 8, it might be a matter of adding language. It says, and I'm paraphrasing here, but, with respect to expulsions made under step 8 of the student code of conduct, an appeal would be available consistent with the student code as stated, or something.
Yeah, something like
something
that.
to that effect is what I'm hearing would be the suggested add under. It says long-term suspensions and expulsions. I think it's just expulsions, but we can pull the student code and make sure that clarity is provided.
is there any objection to that I'm seeing for them to look into that?
I have a question maybe along the lines of that, maybe not an objection, but first I just want to clarify something. This says student code of conduct in it, but then you reference the student code of conduct. Is there two different documents that we call the student code of conduct? And semantically, should we not call two things the exact same thing if they are two different documents?
Yeah, so this, excuse me, this policy on student code of conduct says the superintendent will develop and implement a legally compliant student code of conduct. So the policy is drafted, contemplates creation of a document. I apologize, I don't know. I use general nomenclature like student code. I don't know if the district calls it a student
We
handbook.
do. That's why it stuck out to me. That's
yeah.
why it rung a bell to me that it seemed like we were referring to two separate documents. So it may just be a semantic one where we do want to call them two separate things.
Different districts call them different things. Some call it a student handbook. The intent here, though, is for the board, in essence, to direct the superintendent to draft that document and have that document, one that complies with law. What does that mean? 7 factors, restorative practice, all that other stuff that would be included in the student code of conduct.
So to President Butel's specific point around an appeal process, so I submitted a policy to the board. I don't know if it ever made it to you guys. I can send it over to you. I think we really should have basically a formal complaint against, if anyone feels a policy has been violated, there should be a standard policy in which we follow to allow basically due process. That would cover something like this. Obviously, if you were being long-term suspended, you would have your due process. I would think something like that would be all-encompassing to basically allow for there to be, one, again, the specific, you have to file it against a specific policy, which is any policy in here, you'd have to file and say, hey, I feel this policy's been violated, and then have a due process for that standpoint. And again, it obviously covers a situation like President Patel is bringing up.
I guess my response to that would be that this section is specific to student discipline and is intended to address the discipline of students. That's in the student section under behavior. I hear the suggestion, and I don't have a strong feeling one way or the other than to say this particular section is dealing with the discipline of students.
Well, I guess maybe my question is then to President Vial's point, would the idea of, yes, developing a policy that's separate, that's complaint, and having the reference be to that policy can be used in this regard, would that accomplish the same goal?
I understand the question, and I'm having two thoughts, and Adam's quicker with the trigger than I am there. We have a public complaints policy in 7005 that gets to the heart of some of what you're talking about, I think, and I don't have the language immediately in front of me, but it is 7005, and that talks about public complaints on a variety of things. I think the concern that I would have is an initial matter, and it's not necessarily one that can't be overcome, is there are a lot of particular legal requirements and nuances to student discipline that might not apply in other situations. And so there's a whole classification of case law that talks about student due process specifically and the standards that are required therein. We know that when it comes to disciplining students with disabilities, there are other rules that are there. And so my only concern about giving you a blanket, sure, we could do that, is I think there's enough particular legal nuance and guidelines in terms of what we can and can't do from a student discipline standpoint that I would be hesitant to lump them all together. That's my immediate reaction. And again, not that there's not other things that can be talked about, but again, my initial thought was the public complaints policy in 7005.
Trustee Blake?
So I can't tell on my copy what the blue deleted word is on the side. Okay, so this is I hate to bring this, I really hate to bring this up now, but this is a disagreement that came up within the committee as to whether or not we should use the pronouns he, she, or we should use the they, them pronouns. And when this came up, I didn't really have an opinion on it, or I didn't take a position on it initially. And for this reason, but I've now come to believe that we should change it to the they, them pronouns for these reasons. Well, first of all, it does feel weird, I'll admit. It's not what I was brought up or taught as to how we use pronouns, the singular generic pronoun, and it does take practice, but language does change, and even in my lifetime, language has changed. At one time, we used he. I was taught that he was the universal single generic pronoun, and when I started college, that's what I thought. In my first semester, I had a professor who refused to grade your papers if we didn't use gender-inclusive language. And that's how I learned to use gender-inclusive language. And so now it's been the standard he, she to use, or he/she, or alternate between the two for, a couple decades now. Well, at this point, it seems that language is, again, in the midst of changing. And so I wanted to look and see what the recommendations were of best practices. So I looked, first of all, at the APA style book, which is used for scientific journals, textbooks, academic papers, and so forth. And what the APA style book says is when referring to a generic person whose gender is unknown or irrelevant to the context, use the singular they as the pronoun. For example, if you use nouns like person, individual, or everyone, or phrases like every teacher or each nurse in a sentence, use the appropriate form of the pronoun they. So then I also was looking at the AP style book and what they recommend, which the AP style book is for newspapers and magazines. The AP style book, since 2017, has offered they, them as a choice. They also recommend that you can rewrite the sentence if you want to avoid the pronoun. And there is controversy now. People are wanting them to change to that being the only choice. So I also pulled up a half a dozen or so colleges, and on their websites, they now use they, them as pronouns. So I think that we should model best practices. Our students are going to go to college, and they're going to be required to use those pronouns, and we should model what the best practices are in that area.
I'm shocked that this is what you just spent that much time on. It's
I'm very wasteful in time, clearly.
It's a belief that people want to have. If you want to do it, put it in there, they, them, let's move on. You can't compel people to do it or not do it. So Because it's a generic policy and it's not referring to anyone, they, them, make it they, them, let's move on.
Okay.
But
I
that was-
agree.
Wow.
Let's just
It's a
move on.
miracle.
All right. Did anyone else have something? I had one just clerical item under,
I'm sorry, just so we're clear, and thank you, trustee Blake, for raising the question, and because it was something that the committee talked about, and I appreciate, I was unaware of the APA and the AP citation, so I appreciate that information as well. Do I understand then, and I appreciate the pursuit of speed now, am I changing all of the he, she's throughout the manual to they, them? Is that what I'm
Yes.
hearing? I thought I heard just make the change and move on.
Yes.
Is that fair? Okay, I just want to make sure that I'm accurately reflecting what the board has asked for. President Butel, I'm sorry, you're about to make another point.
no, it's just like a typo. The word "to" was left out in the third line of student bullying. I think it's likely to lead, and there's no "to."
Thank you. Adam will make that note, and then we'll take away his next paycheck. Thank you.
I didn't draft that one.
Anyone else have something in 2006?
So around the discipline though, and you referenced, again, administrative regulation, so one of the big issues is inconsistent discipline within our district. I do think we need to pull that into policy. I think there's things we've talked about.
Could you talk about where you are on here, trustee Weaver?
Student code of conduct?
Oh,
So
you're under student code of conduct, okay.
I'll make a statement quickly, and I'll try to be quick, about inconsistency in discipline. And I suspect you were going to give some examples of inconsistency in discipline. The legislative changes undertaken by the Michigan legislature in an effort to be less prescriptive and more mindful of individual student situations, the 7 factors that are articulated in the revised school code that are required to be considered by building administrators before issuing discipline. I'm not here to debate the merits of whether that's a good thing or a bad thing. The reality of the legislative structure that has been given to us, mandated to us, necessarily will create inconsistent outcomes. If we had consistent outcomes, and I'm painting with a very broad brush, we would not be living the spirit of the statute, which says every student situation is to be assessed individually. Every student situation, we are to consider the 7 factors, which consider student age, student disciplinary history, so on and so forth. It is the reason why in student codes of conduct, back in my day, and even when I started practicing, you'd have a student code of conduct that says, if you fight, you get 7 to 10 days. If you're chewing gum, you get 1 to 2, whatever, okay? We have removed all of that prescription. When I say we, I mean the education establishment, in an effort to comply with the legislative changes that have happened, the requirement to use the 7 factors, the requirement to consider restorative practices. And even if applied with fidelity and good intention and all of those things, you will have 5 students in a given year who ostensibly commit the same offense and have 5 different disciplinary outcomes. And people will look at that and say, there's got to be some problem with that. And just so we're clear, I'm not talking specific to Rochester, I'm talking about my experience in representing 100-plus districts. That is the nature of the statutory scheme, because there will be factors in each one of those 5 cases that warrant more discipline, less discipline, no discipline, and that is largely a byproduct, it is entirely a byproduct of the legislative structure. And the reason I preempted the question and offered that is because it is a question that I get a lot about why do we see this? If I lay it out on a scatter plot, why is it not consistent? Why don't we say in the student code, you do actually get 7 to 10 days? And it's because of what the legislature has given us. And while I think very well intentioned and supported by some of the data points that they had, it naturally is going to lead to some of those curious outcomes that don't on paper seem to make sense.
Okay, so now, I think what you're describing, I do think it's just a fundamentally different way of looking at it. It says we have to consider the 7 standards. I've looked at the law, I've reviewed it. So nothing says that we can't develop standards behind those. So to your point, if we develop our policy that says we must consider the seven factors and put a standard process in place that can basically quantify, right? Each one of those has a quantifiable to it, age, number of offenses, like you go down, like you can absolutely quantify that to take out some subjectivity, which again goes back to broad policy, says this is what we're going to do, this is how we're going to consider the factors. But so to say, the law doesn't say that you can't define standards to those 7 factors. That would actually allow us, and again, this is where, yes, some of the work has to get done and some of the detailed process to put behind it, would say, how do we ensure that when we have a system, and again, go back to that teacher that has to, or that administrator that has to do the discipline, they should be able to refer to a document that says, okay, here's the steps, I have to make sure I referred all these, you plug it in, and it basically, yes, to some extent, should be fair, firm, and consistent from a discipline standpoint of what we do. So I don't think that the law actually says that we have to be inconsistent. It just says we have to actually consider the 7 factors. But when I have a factor in one building, that factor should be the same in another building. And if it, one classroom to another classroom, I mean, that's, again, fair, firm, and consistent methodology, but absolutely making into account. The kid that gets in trouble the first time and the kid that gets in trouble the 10th time, you're right. If they did the same thing, their discipline shouldn't be the same.
But again,
we
this
should
would be
able
an
to show that we follow-
operational issue, right, Trustee Weaver?
No, it's not. It's a policy issue. Because again, what I'm stating is the definition of the policy would be at the top level of we will be fair, firm, and consistent. We will consider the 7 factors, and here's how they will be weighted. And then they can develop how they're going to do that.
So,
But to say we're just going to be inconsistent because we have to have the 7
Okay,
factors,
let's
that
let
doesn't.
so a couple.
Mr. Sutton answer.
A couple of thoughts. So, first of all, that should all be articulated very directly and specifically, and it would be my recommendation to express that directly within the student code of conduct, which the policy directs the superintendent to develop to be legally compliant. And being legally compliant would be talking about the 7 factors, talking about those things. There are factors that are not quantifiable, and when you started talking about quantifiable, I started thinking about that math equation that Trustee Blake referenced earlier, but there are some that are not quantifiable, such as are restorative practices good enough to remedy the harm that's been inflicted? That's not really quantifiable. The other part of the law that doesn't get talked about very often is the rebuttable presumption piece.
Hang on, I want to stop you there. Go back to the restorative practice. If that step just has to say, again, if I'm the teacher, it just has to say, did I look at restorative practice? Did I say, was it good or not? Yes or no? That's it. That's quantifiable.
Well, then perhaps my understanding of what you
as
mean
a-
by quantifiable is.
It means,
As a
it means that
person-
you
as
can
a
either do it
person
or
who
not do
does
it.
Trustee
discipline-
Alsbach, please hold off.
If I could just finish my thought. So the rebuttable presumption piece is also part of this equation. And the rebuttable presumption essentially says, and I'm paraphrasing here dramatically, that there is a presumption that you start with that long-term suspensions and expulsions should not happen. That is the presumption that is in the law, and in order to overcome that presumption, you have to consider the 7 factors. There are those who are much more sophisticated in terms of the training that goes on. The answer to your question, which I think is a good one about how do you have consistency from building to building, is one of training. This is the expectation, this is the student code, this is how we want it applied, and that's why, and I don't have specific knowledge of how Rochester does it, but obviously working with a number of districts in the Metro Detroit area, I know, because I've been invited to them, they have these leadership meetings where all of the principals are coming in and they're talking about the data, they're talking about their discipline data, they're talking about situations that have arisen because you want to have that kind of consistency. And in the absence of a document that says, if you commit offense X, it's 7 to 10 days, if you commit offense Y, it's 5 to 7. In the absence of that, the only way to do that is to have training and then to dialogue about the data points that you have so you can have that consistency. Again, Trustee Weaver, I know what you're looking for is that degree of prescription. You're looking for that, this is the list and we're going to quantify it. I appreciate that and I respect your position on it.
Mr. Sutton, no,
Some of
you're
that
inc- no,
detail, I'm not
Mr.
done.
Sutton, you're
I'm not
inc-
done,
you're-
sir.
you're
I'm not done,
incorrect.
sir.
No, but
Trustee
you're
Weaver.
Some of that
incorrect.
detail,
Trustee Weaver.
some of that detail will be contained, should be contained in the student code of conduct as well. And again, I'm not here to say whether it's the good system, a bad system, the right system, or the wrong system until I get elected to a legislative post in Lansing. My opinion doesn't really matter, but it's what the legislature has given us.
But you're
Right, Trustee
misrepresenting
Gupta?
what I said.
So I think it's clear to most adults that if you are using 7 factors to assess children, not buildings, that you are going to have different outcomes based on those individual children's experiences with disciplinary issues. So, because the whole point of the law is to force us to take into context that child's individual situation. So we're not talking about applying 7 factors to buildings equally. We're talking about children. Furthermore, I have a question. Since you have such strong opinions about this and you have reviewed it so in-depthly and studied the law, where is your proposed alternative language that we could consider that you could replace what's recommended with? Show us that, and we can consider that, debate that, discuss that, and then you can see if you can get the votes. Bring that to the table.
Remind Trustee Gupta that we're not voting on anything today. This is a work
Trustee
session.
Alsbach?
Well, I understand my colleagues' desire to quantify this situation, the disciplinary situation, for example, look at the restorative practices, is that good enough? If you've done discipline with students or even with teachers, what's good enough for the victim might not be good enough for the other person, might not be good enough if we're dealing with children, might not be good enough for their parents. A lot of times, even the actual facts, like what happened in the bathroom, are totally in dispute. So these things aren't as quantifiable as they see, and it's just like you said, a lot of times, it's our data points and it's our conversations where we come to a greater understanding of what is appropriate in this situation. So it's not like you can plug this into a formula and spit out an answer, because there's a lot of grays in there, and sometimes there's even disputes on what the actual facts are.
Trustee Lakouи?
Well, I guess I'm thinking about some of this, and it seems like if we wanted to provide some kind of a guide for staff for what you might want to be considering for discipline, I'm not sure that does the law prohibit us from providing a guide as a starting point that you would then use the 7 factors as well, and you could adjust it based on 7 factors. It's sort of the idea that it's not like total prescription. It's not like everyone's going to necessarily get the exact same punishment if you're in kindergarten versus a senior in high school, for instance, because the 7 factors are things like you should consider the pupil's age, disciplinary history, whether this pupil is a student with a disability, the seriousness of the violation. Yeah, these are all common sense kind of things. And you could still have a guide as a starting point, but then as an employee who's administering discipline in some kind of way, you could say, well, I administered this type of punishment, I reviewed the guide, I reviewed the 7 factors, and in thinking about these 2 different documents, that's how I was able to come to my decision. And then you would have a solid reasoning for that. And it sounds like Trustee Weaver's maybe saying we should have a board policy, or you could have it as administrative regulation. Maybe either way would work. I guess I'm wondering, are all of those options actually viable options?
Yeah, no, I appreciate the question, and I appreciate the thought process. I think it's one for those of us that are not in the arena. We think about it from an engineering standpoint, from a manufacturing standpoint. We like things that are linear. We like lists. My grandfather was my best friend, and he used to have a lot of phrases he would say, and he used to say, if it walks like a duck and quacks like a duck, it's a duck. So it doesn't matter whether we call it guidelines or suggestions or possible ranges, it conflicts with the spirit of the statute. I appreciate the question, Trustee Lakoui, because I've had a number of administrators in other districts say, could we come up with a guideline? And my advice has been just that. Whether we have prescription in the Student Code of Conduct or we give you a secret document that has prescription, it still conflicts with the spirit of the statute. I think, one of the things.
Can you tell me how it conflicts?
Because they specifically say in the statute that you can't have prescription, that you have to think about the 7 factors and assess every student's situation individually. So having prescription is the antithesis of having case-by-case analysis.
I guess I just don't understand. The outcomes could still be different, is the thing, because when you're reviewing both things at the same time, you will inevitably have different outcomes, but it's just basically.
So if I give you a
flush it out.
guideline that says student engages in behavior X and the range is 2 to 4 days, and it's just a guideline, as a principal, do I think I can give 0 days then?
Depending on the 7 factors. I mean, you could use the 7 factors in your explanation for why it needs to be a much shorter range of time than what the guide was.
I think, and I wondered if this point arrives in the evening, and I think it has at 8:38. And this is a question that I asked to the policy committee at some point, and I'll ask it now to the board. What are we doing? What are we doing?
Working on policy last time I checked.
Well, no, I think there's a difference between working on policy. I mean, we've now had a 15-minute discussion about what the law is and is not. We know what the law is. We've stated what the law is. We can not like what the law is, that's fine, but we're talking about it this is non-negotiable. This is what the law is, and we're bouncing off the walls about language that you guys have had in your policy manual for I don't know how many years. Are we at a utopian level from a student discipline standpoint? Probably not. But the law is what the law is. There is a degree of collaboration and learning and discussion that goes on amongst building leaders and administrators and staff to try to get the right outcomes, to be student-centered. I'm not a legislator. I didn't draft the language. The reasoning that they articulated for why they did it is their reasoning, but that's the law that we have. This is the reality. We can argue for another hour about whether or not the 7 factors are good, bad, cohesive enough, not cohesive
Mr.
enough.
Sutton,
If prescription
respectfully,
is a
it's
good
not-
plan or a bad plan. I'm telling you what the law says. I'm telling you why the policy has been drafted the way it is. And this is the same dynamic. And again, it's part of the good hard work that the policy committee did that we ran into at one point and we said, what are we doing? We're talking about things that we can talk about it for 3 hours. It's not going to change what the law says and what the application of the law is. Your question was, could we use a guideline? My answer is no.
So,
Even if there was a
agree with you about the
guideline, it
law.
wouldn't be drafted by the board.
What do leaders use when they're doing training for consistency with the leadership training and they're having dialogue about data points? Like, to me, that sounds like the idea of a guideline that you would
But
use.
why would, that wouldn't be in our
follow-
policy, though?
I'm not necessarily saying that. I'm saying, Trustee Weaver brought up it could be board policy as a guideline. Perhaps it could be administrative regulation as a guideline. But I'm just saying, like, I don't understand why that conflicts with the law when you could always apply the law to whatever it is that you have and make adjustments as necessary and follow the law. So I'm not seeing how it actually breaks the law.
All
If,
right, well,
to follow.
if
Let-
you're.
I'm going to have
yeah.
trustee Gupta, she would like to speak on this.
I guess I just have a question. Have you read the Student Code of Conduct? Because there's a lot in there to help guide administrators on, in accordance with the law, on how to move through a decision-making process when it comes to student discipline. And our policies refer to this document for that purpose.
So I'm gonna share. So first of all, Mr. Sutton, my wife's a teacher, so I actually hear from that side of it. So no, I don't always process from the outside laws. Teachers absolutely want more structure around the standards. So I want to make sure what you're saying legally, if we actually say, here is our process, here's how we are complying with the law by considering all the steps, we would then violate that process. And why, yes, I do think it should be in board policy, is the high arching part of it should say, this is the criteria that is minimally required to be in the policy and granted through administration regulations. That would ensure that those specific details have to be driven down so that they can follow it. So I truly want to understand how you're saying if we actually we cannot develop a process with taking the law into account and saying, did we follow the law and considering all the steps, that we would be in violation of the law?
Yeah, that's not what I said. That's not what I
You
said.
literally said the law is
No,
the
what
law.
I
and
said
we're
is you can't have a guidepost or a guideline that says this is what the range would be. You can't say that for these types of offenses, we're going to look at this number of days. Having a process that you go through, having steps, that's what the 7 factors are about. And as I understand, those things are outlined in the Student Code of Conduct. And so there is that resource that is available to staff to look at and understand. So just so we're clear, my understanding of Trustee Lakui's question was, well, couldn't we have some guidelines? Meaning my interpretation of that was ranges for discipline. My answer to that is no, that does not comport with the plain language of the statute or the spirit of the statute. Do I think that administrative staff should be having conversations and looking at their data and talking? I have no idea how often they get together. Most large staffs get together, I don't know, once a month, once a quarter, to have these conversations and look at data and talk about those things. Absolutely. Prescription is not permitted underneath the statutory scheme. I mean, I can't really say it any other way. Prescription is not permitted.
But so that's where I
Right.
think you start.
Trustee Weaver,
no,
I think we
that's where
really
I think
need
that-
to move
no,
on.
No, that's where
Trustee
you
Weaver.
start. That's where you're starting with the part where you're saying we're calling for prescription, but that's not what we're actually saying. We're saying is how do we develop the process which makes sure that we take in the
Okay,
seven factors.
Trustee Weaver, I think that we do
President,
need to move on.
President Bell, you can
and
think
that
that all you
can-
want. Anyways, so to say we cannot do that from a standpoint.
Point of order.
It's a work session.
Madam President, point of order.
Trustee Gupta?
I make a motion that we move on. If we have to take a vote on that, so be it. I move that we move on to the next.
I second.
So then I got a question.
So
How do we
Trustee
achieve
Weaver, do we
equity?
need
How do we
to-
achieve equity and
All
discipline
right,
data
Trustee
if we
Weaver,
can't measure it by
there is a
any
motion
standard?
on the floor that we move on.
How do we measure equity and discipline data?
There is no discussion on that. All of those in favor in
talking
moving
about
on,
discipline.
please say aye.
Aye.
We're talking about discipline.
Those opposed, please say no. That's a 5-0 vote. All right, so we just need to move on down. I know there's a blue section in here. I don't know if anyone has comments on any of the other part. Otherwise, we would move to that blue section.
I think we need to move down to personal electronic devices, but there is one thing lingering from that prior discussion that I want to clarify. I appreciate Trustee Weaver sharing that his wife is a teacher and he has that lens. I didn't know that, and I appreciate him sharing that. I think that's a very important lens to have. Adam's wife's a high school teacher. My wife is an elementary teacher. My mother was a special education teacher. She taught in an EI classroom. I remember to this day some of the stories that came home, student names always redacted, about the things that went on. My mom was an elementary principal. She was a curriculum director. She was a deputy superintendent. And while my mom was doing those things, my dad was spending Monday nights sitting at board meetings because he was on the Board of Education as a trustee, as a treasurer, and as a president. I joke that I went to law school and I somehow ended up in the family business still. My dad was an engineer at Ford and still served his community like many of you do. I appreciate the dialogue. I appreciate the seriousness with which the members of this board take their commitment. As I said, seemingly 12 hours ago when this meeting started, was good civil discourse where people can respect each other's opinions, answer questions, is what I think is lacking in this country as a whole. And so I appreciate the dialogue that we're having. I appreciate the perspectives that are being brought to it. I hope the board understands that Adam and I also bring unique perspectives to this, not just as guys who have JDs after our name, but guys who live this. Adam hears it every night at the dinner table, as do I. Every single holiday with my mom and with my dad, I have to relive the war stories of being board members, trying to get a bond issue passed, and the tough decisions that my mom had to make as a building principal and a deputy superintendent. And so I appreciate that you offered that perspective. And I wanted the board to understand that I don't draft policy and I don't give answers as an attorney only. I give my responses based on the totality of those experiences as a son, as a husband, as a father of 2 kids who are still in school at the K-12 level, as an attorney, and as an attorney who has the great privilege of working with dozens and dozens of school districts across this state. So thank you for that. With that, I think we're at personal electronic devices, and there was a recommended addition that you see in blue that the committee could not reach consensus on. And I admittedly don't recall what the basis was for the disagreement. Perhaps one of the members of the committee can recall. Trustee Blake seems eager to share that. His memory is probably better than mine. Thank you.
Trustee
Yeah,
Blake.
so the suggestion, well, this is, I believe, was already in the policy. And this is that students may not use their personal electronic devices to broadcast or record audio images of staff members, other students, et cetera. And one of the members of the committee wanted to remove this and wants students to be able to do that, which I strongly disagree with. I think it's incredibly disruptive to have kids in classrooms recording. And I'll let other members say their views, but the rationale that was given is, well, teachers sometimes say inappropriate things in class, and this way the students can record their teachers and show their parents. And I thought that was a crazy explanation. So,
Trustee Lakouи?
Well, I'd just like to say, this actually was not originally in our policies. It was in red when we got it with our draft. But what I would like to understand is what, it would be helpful to just maybe talk through, what is the public policy reason for this new addition?
Yeah, just so we're clear, I think trustee Lakouy is correct. I was going back and looking at the original audited version, and I think you're correct. This was in red and somehow got turned blue without the red in it, so thank you for pointing that out. That is accurate. I believe trustee Blake, his recollection refreshes mine that there was a discussion around being able to record teachers as well. My recollection of the public policy reason for adding this language was, frankly, the proliferation of electronic devices on campus and them being used for all sorts of reasons that we don't want to see them used. The most obvious example are, student altercations that you have, 30 students surrounding and pulling out their video camera to record, which last time I checked, we've got surveillance cameras everywhere. We don't need their junior videographer skills. Number of incidents in the bathroom. And again, I want to be clear, these are not specific concerns relative to Rochester. These are more universal concerns that we've seen in representing districts. And so the idea was to put some parameters, to have some policy justification for addressing student activities that involve recording. I will also speak specifically, because again, trustee Blake refreshed my recollection as to the discussion that happened in the policy committee. And one of the things that we talked about relative to being able to record a teacher saying or doing something that a student didn't like were some of the concerns that I would expect the union to have with respect to 32 videographers watching class that closely. That was part of the discussion that took place. But hopefully that addresses your question, trustee Lakouy.
Just a quick note too, if I could, and this isn't to guide any decision here, but this is a current clause in the collective bargaining agreement. Again, I know the collective bargaining agreement doesn't dictate policy. It can be done in reverse, but I just wanted the group to understand that as is right now, this language is in the collective bargaining agreement.
Well, I have a couple thoughts on it. Number one, my first thought is, what about students who might want to use their devices for academic reasons, such as in taking lecture notes? That's really common in colleges. Or what about students who have disabilities who might benefit from something like this?
Can I address that first? Can I address that first?
Oh, pardon. Okay.
Because I want to make sure I answer that
Sure.
question. So
Yep.
again, the language, unless the student has received permission from the persons to be broadcast or recorded. So, excuse me, Mr. Smith, I'm having an auditory problem and I'd like to record your lecture today. Is that okay? Why, of course, go ahead. There's not a violation of the policy.
Okay, so students can just they'll just request those sorts of things.
Yes.
Another question I have is this legal? Because I know that there are court cases that say that students have a constitutionally protected right to record in school, including during class, such as Pollack versus Region 1 School Unit. That was a question.
I've not read.
Are you not familiar?
I'm familiar with Pollack generally. I haven't read it
Okay.
in the last 6 months. I have no concern with the legality of the policy as presented.
Would we want to include any kind of, okay, I'll leave it there for right now.
All right, so a couple issues with this one. So let's just walk through it from a standpoint. If student does record, what's going to happen to him, right? We got to go then to the code of conduct, and then you got to take in all these factors. So again, not clear. One, what you described, Mr. Sutton, there's a fight and people pull out their cameras and start recording it. That's not really what this is addressing, because really, are we concerned about the kids recording, or are we concerned about the fight? People doing stuff in the bathroom, again, are we concerned that they're recording, or are we concerned about what they're doing? This does come back to under the core principle of it being the teachers. And again, as being married to a teacher, appointee Blake's position is not well thought through. Lose the example of police. The thing we heard for the longest time, right, is all police are bad, or some people say, oh, it's a few bad apples. That same logic applies to teachers. Majority of our teachers are doing the right things. Absolutely are doing the right things. A few people are not. And so let's just acknowledge that And so this policy is about really saying, why are we doing that? And so let's address the policy really should be about addressing the specific acts that we know are happening that put our teachers under a cloud of suspicion because we're not addressing it through policy instead of focusing on this. Because at the end of the day, someone can record on their iWatch and no one's going to ever know about it. So this is not enforceable. This is not going to actually make a difference. It's not going to protect the teachers. So if we really want to protect the teachers, let's address the few things we know are going on through policy correctly so that really we establish the trust and we correct the behavior and get rid of this. Because again, this is all noise. It's not really enforceable. It's still going to happen because again, every device isn't disruptive. This is literally just a virtue signaling, make us feel better policy. It's not going to do anything.
Trustee Gupta?
Well, what I just heard is that this clause is part of our collective bargaining agreement, which was negotiated on behalf of teachers. So it sounds to me like what the teachers have told us is this language helps them feel more protected. Am I reading that wrong?
Did you not hear what Mr. Murphy said?
Trustee Annis?
I would also add to what Trustee Gupta said in that we already have an example of an instance where a teacher was recorded and it ended up on social media. And I think not having this in place puts a real chilling effect on the ability of teachers to do their job. So I support including it.
So let's use that specific example. That's exactly what we're talking about.
I'm done.
We're going to use that as an example. This policy would not actually address that because, again, it could be done in a way that the teacher would never know it. But ultimately,
It was done in a way that teacher never knew it and ended up on your social media page that you exploited.
Trustee Annis?
well, and it didn't exploit anything. We made people aware of what was going on, which again, the point I'm saying is exactly what you just confirmed, is it was done without the teacher knowing. So this policy does not prevent that from happening. What was shared was, yes, a teacher absolutely pushing their political beliefs, and the students were amazing in their ability to critically think and actually shoot down the reasons. That is one teacher going way outside the bounds. That could absolutely be controlled through policy. That event puts a cloud over all the other teachers that are not doing what that teacher did. So let's address the problem, which is, again, what the actual specific action was, so we reduce the chances that anyone would feel the need to actually record. Let's address the problem, because again, this does not actually stop a student from doing exactly what was done and the
But
same
Trustee
situation
Weaver, I'm
happening.
not sure that any policy is actually going to stop anyone. I mean, there can be actions against it. You can say it's not right, but someone can still do it. So you could say you shouldn't have any of these.
No,
Like, why have them? Because anyone can break it.
No, some policies are absolutely enforceable and applicable. This is one based on what it actually, you have to look at the actual situation. This one specifically, you are right. We are 100% right. We can't control this one. So to try and draft a policy to try and control it is a waste. There are absolutely things that we can control that we should be addressing.
I guess I would disagree with you, because I think if you have this in here that says that it's not allowed to be done, and it is done, then you have recourse. There's consequences for it. You go to the code of conduct on that.
So you're
But
saying, hang on, you're saying specifically, you're more concerned that someone learns about something that was inappropriate than actually addressing what was inappropriate.
No, no one said that.
That's what this policy does.
No, it
That is
doesn't.
what, we've heard the whole conversation. That is what this policy is about.
Nobody said that, Trustee Weaver. That's so irresponsible.
Okay. Trustee Blake?
He said it, she said it.
I mean, most policies, no policy can stop a person from violating the policy. People break the law. We have speeding laws. We have laws against murder, and people do it. So, but this is about having an ability to have recourse when somebody does violate it. The other thing I'll say is, even though all the discussion is on teachers and how we don't trust them, and we want to make sure to record them so that we can make sure that they're not doing all these bad things, there are also students in the, excuse me, there are also students in the classroom, and students who could be recorded and broadcast. And some of these, all of these students mostly are minors, and this talks about that in here. And so we don't want our students' images to be broadcast against their will and shown on social media. It's just this is a slam dunk to me. I don't know why there's this opposition.
If I may, very quickly, I talked at the outset about trying to facilitate this process, and I think there's a conundrum that we've run into this evening, not one that was wholly unanticipated. And it's the same conundrum that we ran into as a policy committee. And we ran into this situation where we were trying to talk about these tough topics. And the discussions were going on and on and on and on. And people are making good points and saying their thing and all that other good stuff. And there came a point where we said, well, maybe we should have a time limit. We should say we're going to, and I think that the reason we walked ourselves into that situation as a committee, and I think the reason why we're walking ourselves into that situation this evening is because we're trying to give equal airtime, we're trying to listen, we're trying to have that discourse, but ultimately, what are we doing? We're not facilitating the discussion, we're lamenting the law, we're talking about, well, what about this? And again, it's not that there haven't been good questions, because there've been a lot of good questions, but I guess what I would ask is this, and I think we push the committee to do this, and I would push the board as a whole to do this as we continue this discussion. And I had a buddy in college, a great guy, and you'd say, hey, do you want to go to this place for dinner? No. What about this place? No. This place? No. You named 10 places. He never wanted to go to any of the places. But you know what he never did? He never once made a suggestion on where we should go to eat. Not one time. And so I feel like we're starting to suffer from a little bit of that. I don't like restaurants A, B, C, and D, but no one's got a suggestion for a place where we can go and eat. And maybe it's getting to the point in the evening where my analogies are getting corny, but I keep hearing no, but I'm not hearing any suggestions for what else we can do. And so while I would have hoped that those suggestions would have come to the fore during our policy discussions in the SPCC, they didn't. On some they did, but we're here. So either it's I've got a way to improve it, or I'm going to vote no on it. Or I don't have a way to improve it, and I implore you to vote no on it, or vote yes, or whatever. I don't care. But the point is, the way we're going at this and just saying no, 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 let's offer some suggestions on what we might be able to do with it, would be my suggestion as a facilitator of the process.
Madam President.
Trustee Lekui?
Okay, so first of all, yes, policies are deterrents to doing some type of behavior, especially if that is enforceable. And it's important to know the purpose for the policy and how it's going to be enforced. So that's why I first started out asking, what's the public policy reason for this? Now, if the public policy reason for this is because we're concerned about students using their cell phones inappropriately like that, I mean, I agree, that's a huge problem. And if they're using their cell phones to harass and bully each other, that is a problem. Perhaps that kind of scenario is actually already addressed with our student code of conduct and the 7 factors and all of the stuff that we talked about earlier. So we can address harassment and bullying in that way. If we're talking about the other example that was brought before us, where there was a student who felt so uncomfortable in a class that they felt a need to record their teacher to show people what was going on, we need to think about what is the real problem that is occurring here. Trustee Weaver made a point that, that's not what most teachers are doing. But of course, there's always an outlier anywhere in any profession where someone might do the wrong thing. And what about our students? Don't we value and respect them and their viewpoints and want them to be able to have the substantiation to support whatever claim they have? Because in a classroom, there is a power imbalance between teachers and students. And it becomes this person's word against this person's word. And a student is at a disadvantage in that scenario. So if a student is put in a position where they're so uncomfortable, they feel the need to do that, and they want to be able to show their parents what's going on, I think that a student should be able to do that and provide that substantiation. So often we hear, oh, that's not going on in the schools. Where's your evidence? You don't have any evidence that's going on. Well, yeah, if we can't see what's going on, it's very hard to produce evidence. But if a student feels that strongly about it, I think that's what we need to be considering. So instead of saying, no, we shouldn't do that because of this and this, let's just try to get to the crux of the issue.
So did you have any?
So my suggestion is this section, just like in our board policies before it did not exist, I would not recommend including this one because I think that the first reason that we talked about is already covered in terms of our student code of conduct. The second reason isn't really a good reason to include this because it's actually not fair to our students.
And so I would say I agree with what Trustee Lekui just said, to the point specifically, Mr. Sutton, this is why these conversations actually aren't productive, because you're not addressing what we're saying. This one specifically, yeah, it's take it out. That's the answer. The other part is this process has not been fully developed. As of now, I'm learning a lot tonight. I'll gladly start sending more information, but I had to gather some of this information, learn some things from you, hear some things. This was all done behind a closed door. Board policy is part of the board's responsibility. So you're right. I'll have much more information to be able to start suggesting. But to think on the fly that policy is going to be developed here at this board table, that makes no sense when, again, you know how much time you spent in closed sessions out of view of the community. I think our community's learning a lot tonight. So we'll keep moving forward through the process. Again, hold another half.
Excuse me, I'd like to just clarify that our SPCC meetings were not closed meetings per se. I think you're referencing to an OMA violation. There were only 3 trustees in that meeting. Thank you.
Out of view of the public.
You told me they were closed meetings when we were in those meetings.
Well, so.
Trustee Gupta?
Can I just, real quick, because there's a larger implication in what was just said. The larger implication in what was just said was that I, as legal counsel, allowed improper closed sessions to go on after an expression that there was a closed session. I can categorically and unequivocally state that did not occur. There was no indication, no discussion of the session being closed, of it being called as a regular meeting and moved into an executive session. Absolutely not. As a matter of law, committee meetings do not have to be posted under the Open Meetings Act as a matter of law. But the notion that they were somehow a closed session, as the public understands them, is patently false and patently inaccurate. And I certainly would not have sat there as a party to that if we were committing an OMA violation.
Thank you for that clarification as an attorney.
They were closed to the public. The public did not see them, and clearly
Trustee
some
Weaver?
decisions were being made. I'm clarifying. In no way am I saying an OMA violation was made. I am saying no. I'm not implying that in any way. But I'm saying in the spirit of transparency, our board and our district has chosen not to be as transparent as possible. This process was done out of view of the community. And again, that is what I meant by closed, and in no way was I implying that there was an OMA violation.
No, nothing was illegal about what we did,
Trustee
but we had a
Lecouey,
choice.
I've called on Trustee Gupta. Could you please allow her to speak?
Sure.
So I'm confused by the statements around saying that this is like coming out of nowhere. You had no time to review this, no time to put together suggestions and share them with us. That's insane, because we have all received regular updates about what's going on, and we've all had this for, what, at least a week now or more? The final, draft that we're reviewing right now, and I have not received one message from you, Trustee Weaver, proposing any alternative language or changes. I have not heard you provide any constructive ideas that are contrary to what is in this document until we've gotten to this very meeting. So it is, for you, if you don't read your email, that's on you. Don't put that on the board as if we're not doing our work.
So I'll address that. The premise that somehow reading a document is the same as what we've gotten here tonight, of having feedback, dialogue, learning. Again,
Okay, can we
this is
get
just
back
the
and
absurdity of
focus
what we're dealing
on
with
what-
at this table at this point.
Well, that's exactly my point. Let's get back to what is on the policy that is here so that we can move through some of it. On this section, I'll just say, we're divided. I don't think we'll come to a consensus on this at this point unless someone has some miraculous, ideas that they'll share at another point.
What I would say is this: it's our recommendation to include it, and I would include it in the first reading, and I'd ask the board to vote on it at its next meeting.
Thank you. Is there anything else under 2006? Okay, I guess on to 2007.
I'm going to regret asking this, but there's no discussion
Wait,
about
yeah,
student
no,
activism.
yeah, hold on, wait. Yes.
So just so we're clear and there's understanding, student activism was a proposed policy that one of the committee members brought to the committee. It was not a recommended update, but it was a discussion that we included some draft language and then had a collective dialogue around, and ultimately as a committee reached the language that is advanced before the board this evening. Just so there's context for history, I believe being asked during the committee meetings if I thought a student activism policy was a good idea, a bad idea, if we needed one, if we didn't need one. And I think my answer was something along the lines of, it's not in our baseline policies. That doesn't mean you can't have one. That doesn't mean I'm saying don't have one. Again, this is what the committee came up with under student activism, but it was a committee-initiated addition.
Thank you.
So I'll ask directly, how does this comply with the closed forum? If I'm a teacher, can I shut down all student activism based on the closed forum policy? Can I just say, look, I don't want it disrupting my class?
So, as I'm sure everyone at this table is aware, the First Amendment rights as it relates to students are fairly clear as you go through the Tinker line of cases. And there are updates and there are changes over time. The ultimate regulatory authority as it relates to student expression is whether it's a material disruption to the school day. That's the ultimate, that's the baseline, that's the conversation point as we go through these conversations. This does not conflict with the closed forum policy, because the closed forum policy is specifically focused on our ability to regulate the public and the public expression of speech. That doesn't necessarily mean that students shed that First Amendment right at the same time. So I recognize that is a very fine nuance, but it is a nuance that I think is accurate. Now, again, our baseline policy does not include a student activism policy, because I do believe this muddies the water. However, the board and the policy committee have the ability and the authority to do what they want to do. This is your policy. This is what came through the policy committee process. And while it's not part of our baseline, we've put together language that we believe complies with the legal obligations of the district.
Trustee Blake and then Trustee Gupta.
So this one was proposed by a member of the committee, and this is one that most of the people in the committee didn't think we needed, but this is, and we spent a ton of time working with the language to try to get to something that we could agree to, and this is one of many examples of compromising with other members of the committee to have this, and we ended up in a real roadblock at the end because somebody wanted really harsh language in here, in my view, on what should happen to a student who engages in, quote, political activism. We ended up with this disciplinary consequences may be imposed, but, this is an example of the people in the committee trying really hard to accommodate the views of other people.
Trustee Gupta?
33%.
He answered my question, thank you.
Okay. All right, well, I'm willing to support it since the committee worked on it to come to an agreement on this, so. All right, I think we're on to 2007.
Going once, going twice. Any questions on the minor additions? Yeah, the biggest addition is the language relative to opioid antagonists to supplement the EpiPen language that you have under health and safety.
I just had a question on 2007, is it that the wellness policy, which has been adopted, is that first sentence? Is that, it says the school district is committed to creating a school environment that enhances lifelong wellness practices. As required by law, the board has adopted a wellness policy.
Is the policy the first sentence?
Yes.
No, I think the intention of wellness policy is that there are, because the district is required to have a wellness committee and various documents that govern the activities of the wellness committee, that is anticipated as what the wellness policy is. It's funny, when you say it out loud at 9:30 at night, it sounds kooky. And so I would not be opposed to a revision of the capital P policy to include the formal name of whatever that governance document is that oversees the activities of the wellness committee, which we're required to have by law.
Because then, does the board technically approve it or adopt it?
Yeah, I think my response is that the capital P policy is probably not the right word there. Most districts call what that committee does a wellness policy that governs their activities, but it's not a policy in the classic sense of the word. So I would have no objection to taking that capital P policy out and replacing it with the name of the document that the wellness committee utilizes. to guide its activities.
Which then, just to follow up, the board would adopt that. The board would have to adopt whatever that wellness document is.
Sorry, turned off. Yes, that would be correct.
I could also propose an alternative, which is the board will establish, or the superintendent will establish a wellness committee, which I think would also comport with the law.
Yep.
And then we don't necessarily have the policy, that P word, right? That P word is very problematic.
I like that because that specifically identifies what's happening, that there's a committee that is established that is working on this.
Absent objection, we'll make that edit.
Anyone else have something in 2007?
Well, then that means we've completed the 2000 section. Oh, no, we didn't. There's more. No, that's it. Cardiac emergency. Okay, we're good.
3,000.
So I'd be remiss if I didn't at least pose the question at 9:14 of what is the plan? Clearly, 3 hours per section is not acceptable. I don't, it's unclear to me based on the last several hours what the level of preparedness is to call out specific things that individual trustees have questions about, in terms of saying, I want to talk about this one, and this one, or if a sort of rolling through it, as we have been, is the preferred methodology. I admittedly didn't seek to short-circuit the conversation, which is why I thought, well, we'll roll through it and see what people have. Now we've got a data point, it's 3 hours, so I don't know that that's going to be palatable, and if the board wants to have, 7 more work sessions, I'm happy to come back, but I'd be remiss if I didn't at least ask at this hour what the game plan is.
I'll say, I think based on the history of knowing how bad these policies were and no one really is reviewing them, maybe since 2020, I absolutely think we need to go through each one and understand why they're there and what their function is and what changes we're making to them. And if that means we hold more meetings and do the work, that's absolutely what we should do. But knowing, again, where you explained where this thing started and where we're at, to just skip over anything and not do our due diligence, I think would be a failure of the board.
Well, I don't think he's saying not to do the due diligence. I think he's saying that individuals would identify if they had a question in a section. I mean, we all have access to it. The public has access to it. It was posted. So I think it's a matter of, staying on track, not having the theoretical discussions about why policy, the way they write policy is different from another. So I think that's what we're looking at to try and move through these maybe a little bit faster.
I'll just say again, because most of that I didn't say, I think because of not going through it, how we've been doing it has been detailed, and making sure that everyone understands what's in here is the proper way to do it.
But do you foresee when we would finish these, if we continue at 3 hours per section?
I'm more concerned in getting it right than getting it done fast. That means you schedule more meetings.
But Trustee Gupta.
Could we take a vote maybe on how we want to move forward so that we can just figure out what the majority of the board would like to do?
Could I offer a suggestion?
Please do.
There are some blue items remaining, I believe. A lot of work, a lot of good work was done on this entire document in good faith. A lot of compromise, a lot of discussion. All board members had access to know who was on that committee. Many forwarded questions to be addressed along the way. Everyone had that right. Everyone has the ability to decide how they want to proceed, and you have the ability as a board to decide that. Another path here would be to cover, with little time we might have left tonight, the areas that we couldn't agree to, or that you, the 3 committee members, couldn't come to consensus on. So at least if this is to go to a future board meeting for approval, all of those items have been addressed. I mean, in the end, I think we're going to end up, whether we take 10 more minutes or 10 more hours, with a package of policies that would go forward, that everyone's sort of on the same page with, and then a set that people don't agree with. And with the set that people don't agree with, they're going to be making individual motions, and it's going to be the will of the board on how those go forward. So I would just suggest that tonight, at least we try to get through what the subcommittee couldn't come to consensus on.
just
Just
to-
my suggestion.
Just to give some context to Mr. Murphy's suggestion, I did a quick flip through. I don't believe there are any other blue markings in 3,000, 4,000, 5,000, 6,000, 7,000, or 8,000. And again, I want everyone to understand that. That means that the committee thought that 3,000, 4,000, 5,000, 6,000, 7,000, and 8,000 were good to come to the full board. There are, by my count, 4 blue items in the bylaws. Strike that, 3 in the bylaws and 1 in the introductory section.
Kevin, there's one blue item in the 3000s, which was the controversial issues and materials
Oh,
policy.
I apologize. I must have missed that as I was flipping through quickly. Thank you for pointing that out. No, that was a delete. That was a delete. The committee deleted that.
It's in blue on our sheet because it was something that we still wanted to propose to the board. The committee discussed it, but the committee doesn't have any decision-making power. It's just an informational committee. But really, it's up to the full board to decide
So
on these items.
This was not something that was in the policy before, right? This was a proposal that the committee did not agree to adding?
Yeah, I believe this was a proposal that was advanced by a committee member that
Mm-hmm.
was discussed, and we had highlighted it in blue for a discussion item, and ultimately, the committee decided not to move it forward. And so it was not existing policy, it was not a recommended update from our firm, it was a policy that was suggested by a member of the committee. And
Oh,
the
that's
commi-
interesting. Because I've been told as a board member that when you want to propose policy, the process is to put it through the SPCC first, and then the SPCC discusses it, but they have no decision-making power because they're just informational. And then after that, it would go to the full board, and that's what I've been told when I've brought forward
Well,
policies
no,
before at board
I guess what I
meetings.
would say is that you are correct in that the committee does not have the ability to make decisions on it, but it also doesn't mean that one person gets to bring something forward either to be included.
Oh. So how does one person bring forward a policy to the board?
It would
for
be the same
consideration?
thing. You need to find 3 other people who would like to be included, well, for voting, for it to approve it, you would need 4 people who would approve the item. I've said I would put anything on the agenda that you and 2 other people wanted to discuss.
Okay, so I really ought to go through the normal process that I do where I just try to approve the agenda.
Well, I
If I'm
think
not, if board
the
colleagues
idea
are not
was
willing
to, anything could come through, if the 3 of you had agreed, right, then there would be your 3 people to add it onto the inclusion here.
Can I?
We've had, wait, hang on, we've had multiple items on here, specifically the blue ones, that all 3 people did not agree to, and all of a sudden, this one blue one is
So-
the only one we're not going to talk about.
Just so
Making
we're
the
clear-
rules up as we go.
Just so we're clear, my comments were simply intended to recount what transpired and why it's in the margin.
Here's my understanding, and somebody correct me if I'm wrong, but the way I understand this is it's true that if there was a policy brought by a member of the committee and that there wasn't consensus, that somebody on the committee still wanted to bring it forward, but there was an agreement on that, then it would still be included. I thought with this one, and again, somebody correct me if I'm wrong, ultimately it was brought by a member of the committee, but that the committee, the 3 members of the committee ultimately decided collectively to drop it. Isn't
That's
that-
incorrect,
It's incorrect. Okay.
right?
Is this a process you guys are following
And
documented anywhere?
that's the reason it's in blue, and that's what when I was in the SPCC committee meeting, which was a closed meeting, it's not a violation of Open Meetings Act, but it was our prerogative as a committee to choose whether we would want that to be an open meeting or a closed meeting, and we choose to have it the committee chooses to have it a closed meeting. So, okay, but I was told in that committee that this was going to be in blue, but that it would be brought forward before the full board, because this is the time to bring forward policies. This is when we're working as a board on all of these policies. And so that's why it was brought to the board right now. And, I mean, my impression and what I was told was that it would be discussed when we talked through the policies, but it looks like that is changing now.
Yeah,
And that's what I'm
So let me just provide some clarity, and I want to be transparent and sincere in my comments here. As we work through these items as a committee, I was taking notes and making edits in real time. My understanding from where I was sitting when we had the discussion was that we weren't moving it forward, which is why it was simply deleted, even though it was in blue text and it was one of the items that we were scrolling through and talking about because we were hitting on the parking lot items, which were in blue. I want to be crystal clear. There was no intent to have a different rule applied to this proposed policies, to have a different set of standards for it. If this is an honest mistake by me, I apologize. My recollection was that the committee was saying, don't move it forward. If there was an expectation that it would be discussed, that's fine. I know it's hard to read what's there because I think it was green text with blue and it's very small. I've got zero concern if we want to pull out a controversial issues policy and have a discussion about it. So I want to be clear about that. If this was an editing error on my part, I apologize. But my recollection was that the committee said we're not advancing that to the board. But maybe I'm mistaken.
I would love to hear why people oppose it.
President Butel, can I comment on this?
Trustee Blake?
So this was a policy that was proposed by a member of the committee. I think this originally originated with a non-member of the committee, and then we talked about this over the course of 3 or 4, I think, different meetings, and at the end of all that, my recollection is that with Mr. Sutton, he had talked about the difficulties of implementing such a policy and how it's not, some districts have suggested doing it, but it's always been problematic. And I thought at the end we decided not to do it. But if that's a misrecollection, I'm fine with discussing it. I'm not trying to stop a committee member from discussing something. If we want to do it, we can discuss it. So should I discuss it?
If it's the will of the board, it can be discussed.
Okay, so this is another example of a policy that one member brought forward. The other members really didn't think we needed, but I worked really, really hard on the language, and we went back and forth on this. There were 3 areas where ultimately I couldn't agree with the policy as proposed. And so the first one is that the member wanted it specifically set out within the policy that a gender identity was a controversial issue and that it had to be follow this specific process, and I thought that we didn't want to do that. The second thing is that, and I can't read the language the way it's blued out here, so I'm just going by memory here, that a parent could object to any type of lesson plans or whatever that was in violation with their own personal beliefs, and there was a whole process, and we were told, I think by our council, that the only thing that, or the third thing was that a child can be opted out. And I think we were told that the only thing that a child can opt out is sex ed. And what I didn't want, and the way I thought it was listed, was that one parent's political, or not political, but personal or religious beliefs would kind of dictate what other kids learned. And I think a parent should have a right to do that with their own child, but not with everybody else's children. So we never found the right language. We never landed on the language that we all 3 could agree on.
And if I may, I'm happy to, I've pulled up, I have obviously a number of versions of these documents that we looked at, and I'm able to read it on my screen, and I'm happy to share what the text of it was with everyone if that would be helpful. So the policy was entitled Controversial Issues and Materials. The board will permit proper educational use of controversial issues/materials in the instructional programs provided that such use is communicated clearly and promptly to the students and their parents/caregivers. A controversial issue defined for purpose of this policy is a topic that may be deemed contentious and is likely to evoke polarizing viewpoints. Examples include gender identity, politics, religion, race relations, and sexually explicit language. The vast majority of the students in the district are minors. As such, the board will approve the inclusion of controversial issues/materials in classroom, provided that they are pertinent to the learning objectives of the courses or program, semicolon, they're aligned with the student's maturity level, semicolon, their instructional use will not in any way attempt to indoctrinate students or sway them towards a particular viewpoint, semicolon, and they're introduced in a spirit of scholarly inquiry that promotes exploration of all sides of the issue and engagement in constructive and civil discourse. The board recognizes that a course of study may have content that some parents find objectionable. A parent may file a complaint in accordance with board policy that cites 3006 parental objections regarding the content and its instructional use that the parent finds to be in conflict with his/her value systems. The school will consider a request to exclude his/her child from specific lessons or to provide alternative learning activities while not in attendance for those specific sessions. So that was the language that we talked about, and it looks like the edit was made on February 2nd to remove it, which was our final SPCC meeting.
All right, so
Trustee Lekui?
I'll go ahead and talk about this because I presented this one. The controversial issues and materials policy exists because policies are there to try to protect people, basically, also outline expectations so that everybody knows what the expectations are. And we've had some issues with controversy, with the classroom, where there's teachers and parents who are nervous about each other. Parents are nervous about what's going on in the classroom. Teachers are nervous that parents are attacking them. And the point of this is to sort of kind of build a bridge between everybody so that everyone knows what's going on. That's the point. And it's to say, look, we're not saying you can't talk about controversial issues. Controversial issues can be good to talk about. It can promote critical thinking, as long as you're doing it in the right kind of way. So it should be viewpoint neutral. You should present all sides of an issue, and you can have really good discussion and learning from that. And parents should just know up front, if you're going to be talking about a controversial issue, this is what it is. And that way parents have the knowledge of what's going on. They can talk with their kid about it and make sure that kid is ready, or they could opt out their kid if it conflicts with their particular values in a situation. So we got sidetracked talking about lots of different things. It absolutely does not give parents the ability to control, what all the kids in the classroom are taught. The specific language there says a parent may file a complaint in accordance with Board Policy 3006 regarding content that the parent finds in conflict with his or her value systems, and the school will consider a request to excuse his or her child from specific lessons or provide alternative learning activities. So it's really just focused on that particular family. It does not mean that one parent is dictating what's going on in the classroom. The teacher has the prerogative to decide what's going on in the classroom. But here teachers know too, like it just lays out, here are the expectations. And it makes it clear for people, just laying out expectations so everyone knows what to expect. And that was the whole point of including something like this. And I'm open to feedback and adjustments, but that was the general purpose.
So I'm happy to share very quickly what some of my feedback was during the committee meeting. And I don't know if I did it at the time, but Trustee Lekui clearly spent a considerable amount of time putting thoughtfulness into this and trying to come up with language that she thought made sense. My comments then and my comments now will be limited to two. Number one, I think there are a host of legal complications with the language as proposed. And two, I wouldn't recommend its adoption. Thank you.
Why does Neola offer a policy that's similar to this, but actually more fleshed out, that several districts use?
I can't speak to why Neola does what Neola does, and I can't speak to what other districts have or don't have. I think Trustee Blake mentioned that I did comment that there are those districts that have gone down the path of having controversial issues policies, and they have largely found that having a controversial issues policy is rather controversial. And so my recommendation is not to adopt it. But again, my recommendation is my recommendation. This is, as I said it before, and I'll say it again, this is not the Kevin Sutton policy manual. It's the Rochester Community Schools policy manual. My job is to facilitate, give you my insights as a practitioner, someone who actually does this work on a daily basis with schools and helps navigate the situations that arise day to day. My recommendation is not to adopt it.
So you're saying that having a standard in place that identifies how we communicate topics that are, again, defined by standards that are known, right? All those words in there are things that can be defined and described, just like we saw in the other policies, that requiring that we are transparent and we communicate with our parents and we say what we're doing, that's a legal problem. Please explain what the legal problem is in doing that.
So first of all, I know that there's been a lot of discussion tonight about requests for prescription and understanding what certain words mean. I don't know that I could have been any more clear in my statement. I don't recommend its adoption. My first statement is that there are potentially a host of legal complications.
What are they?
Associated with this language, and I detailed them for the committee at the time. One of the more pertinent concerns that I have, and I know we talked about opt-out forms when we met as a committee, and there are opt-out forms that have floated around. There have been some that have been advanced in districts that are more broad. There are some that are more narrow, and I believe, as Trustee Blake accurately recalled, we had a discussion about that, and my guidance was that the only permissible opt-out under Michigan law is for sex education. Other opt-outs that are more broad in nature want to be opted out of individual lessons or being in a room where gender-neutral pronouns are used or whatever are not enforceable under the law. And so, without going too far down the rabbit trail, those are some of the legal concerns that I have, and those are just the beginning of them.
But those
Trustee
don't
Alsbach?
address the points.
So I was privileged enough to work with a program that was across 58 different school districts across 9 different counties. And we worked with a lot of students that didn't find traditional classrooms being their most comfortable area. So we were dealing with a lot of families from diverse backgrounds that had very strong religious views of many different religions. And we tried to work with our families if we got to situations where they would object to it based on their cultural, religious, or moral beliefs. The challenges we found, and I'm particularly thinking of middle school ELA, where a family would say, that novel does not project, in this case, it was a family dynamic that the family's religion supported. So we got into situations where we were wondering, like, okay, so now the burden is on the teacher to somehow create, that student still needs to learn those standards, and those standards are by no means particular to that novel. But now the teacher now needs to create an alternate unit. And sometimes those units, when you work your way through a semester, a novel, it was a significant amount of time. And then the other challenge we got to is, if there was, sometimes we find this in science classes, and now sometimes in social studies classes, sometimes in ELA classes. Generally, math was not controversial. But, if a student is opting out, at what point of an opt-out have they opted out of enough of the standards that the district is no longer in compliance with teaching the standards we have to teach for the tests they will get to, or for just our responsibility to teach to the standards? So I'm just saying that when you live out this issue, those were things we ran into. And some of them were, kind of real sticky widgets for, a burden on a teacher, a conflict for a family. So I've lived this out, and I found it to be pretty disruptive, burdensome on the teacher, sometimes exclusionary to the student. It wasn't a good solution.
All right, so.
I guess what I'd say is that it looks like we don't have a majority to support this at this time, and I think we should move forward, because we're never going to get to
I'm going to make one
them.
more comment. So the controversial material policy is actually designed to address what appointee Alsbach just said. It is to put the standards in place. Right now, currently today, our teachers deal with what was just described. Again, my wife teaches high school language arts. People complain about this book or that book. The idea is to put the standards in place so that the teacher can say, nope, here's the policy, here's the procedures, I'm within bounds. They are broad. The policy is written, and again, it was changed to get to the committee, is very broad. It allows for a lot of, again, really age-appropriate ability to touch almost any subject matter. It just provides the guidelines and is transparent about it. But the situation that appointee Alsbach just described is already currently going on, and teachers deal with that every day. The controversial materials policy is designed to help bridge that gap, put the right guide rails in place. And yes, the fact that we're hearing that English language arts and history and even science, but math's not controversial, that just right there tells you how much we've allowed, yes, the mentality of this DEI woke ideology to infiltrate everything. So again, the controversial material policy is designed to put the rails in place to the point where teachers can do almost anything as long as they are actually following the process and being clear and communicating it.
So if I may, one of the things I think generally, and I remember my dad being at long board meetings, I've obviously been at a number of long board meetings, and I'm sure many of you have as well. One of the things that's interesting about long board meetings is how things reveal themselves over several hours. And so at the outset of this discussion, there was concern that the word obscene wasn't defined clearly enough, that the word vulgar wasn't defined clearly enough, that common sense interpretations of general community standards weren't given crystallized detail and prescription. And now we're going to apparently shift gears, and a phrase like the parent can file a complaint regarding instructional use if the parent finds it to be in conflict with his or her value system. Now, listen, I'm not the world's leading expert on what's vague and what's not, but that certainly strikes me as a hell of a lot more vague than vulgar or obscene. And so from a drafting perspective, from having a cohesive document perspective, what I would caution the full board is this. We can't say words are underdefined and we need more prescription here, but then in certain select situations, say this general vagueness, which no one can really define, is good. I would say from a policy drafting standpoint, that's an inconsistency that will lead to operational problems in the long run. And so I would be mindful of that as we move forward.
That's a fair criticism. So that's the complaint portion of it. Take that part out, and the controversial material policy up and all leading up to that point still exists about putting the guardrails in place. So again, agree with you. The complaint part of it is probably not clean enough, could use better language. We can figure that out. Again, it actually goes to just do the separate complaint process altogether. That way, if you violate the controversial material policy, it's a standalone process. We talked about that earlier. So, but again, you didn't address anything of the actual controversial material policy and the standards which are defined as far as setting the guide rails, communicating properly to make sure that, one, teachers are protected to say, hey, if they are within those guide rails and parents show up and complain, we will stand behind those teachers and say, no, look, they followed the process, it's within the standards. Again, parents, sit down.
I appreciate the concession, and that shows what can be accomplished when we offer suggestions instead of just saying no. I don't need to advocate for the policy, Trustee Weaver. It's not my policy. And this is not my policy manual, which I think I've said at least a dozen times since we started. It's your policy. My job is to say what I think the problems are with it, or the virtues of it. I understand what you're trying to accomplish. I understand we had, again, a very lengthy discussion about this within the committee, though it's apparent that you maybe get some more drafting credit, and I gave all the drafting credit to Trustee Lacouille. Again, I don't have to advocate for it because it's not my policy. It's on the folks who've brought the policy to advocate for it, not me, because it's not my policy manual.
One thing I wanted to say, since Trustee Alsbach brought up a question, and I can directly answer that, and I understand my answer might present other problems because perhaps it's part of this vagueness problem, but in this policy, it says a parent may file a complaint in accordance with Board Policy 3006, which we have in our document here, regarding the content. The school will consider a request to excuse his or her child from specific lessons. It doesn't guarantee anything. One reason I did that was I thought it offered enough flexibility to actually use your own judgment depending on, what it was that they wanted to be excused from. Just in case it was really ludicrous that a parent wanted to excuse their child from something that, really needed to be taught. In any case, maybe Trustee Weaver's idea about having a regular public complaint process would address that concern too. But in any case, that's something that could be flushed out.
Trustee Blake?
So you just read that we will consider a request. What standards? What is the equation? What things do we, all the questions that Trustee Weaver asked over and over again about every other policy can be asked about that policy. And it's a very astute observation that we're completely flipping our approach when it's a policy that we want to advocate for.
I'm the one that wrote this. He's the one who's advocating that, and I'm acknowledging he might be making a really good point. I don't write policy in my regular day-to-day life. I did this to try to give some flexibility and use some common sense judgment. Maybe I was wrong, but I'm just explaining what this actually says to address her question.
Trustee Gupta?
Well, just to clarify, Trustee Weaver proposed this policy a while ago, independent of this process. Well, it's pretty much the same policy, give or take a few stanzas, maybe words. I mean, it's by and large the same topic, same overarching themes, and same outcomes that you're looking for here. So, and it is of note that, you know, when it comes to something that you're advocating for, all of a sudden subjectivity is acceptable. However, you know, on everything else, we need to have everything measurable and quantifiable and everything
Open to
else.
suggestions.
But the suggestions probably should have been proposed before we got to this meeting, so that we had time to consider them.
Didn't you just say you had the document?
But I'm a hard pass on this either way. Thanks.
Of course you are.
Okay,
So-
so right
wait,
now,
wait,
it is 9:45. We need to decide what we are doing at this point. I think it's getting late, and people are losing their temper, not to mention being tired. So at this point,
So wait, I just want to I am going to make one more point. We had legal advice specifically for the added language, and he recommended what I suggested. So this does have legal support. If you want to
I'm
debate
sorry.
it, debate it on its merit.
Trustee Weaver, I think you missed what he said. It was not recommended, and it had legal complications
I'm
to the
telling you
language.
that other lawyers give different opinions,
Oh, okay,
and we pay them both.
all right.
So, President Butel, what I would say is that was the lone blue issue outside of the bylaws and the introductory section, which is the first three policies. So the remaining blue is on the first page and then in the bylaws. As enjoyable as this has been, it's been a long day. And I apologize, I've been under the weather. I don't particularly care to have much more discussion this evening on this topic. Plus, Adam's computer's about to run out of battery. Actually, well, no, I was really kind of hoping there was no extension cords, but I think moving towards wrapping this discussion for the evening, and clearly there will need to be some additional work session process. Now, whether we follow the process that we followed tonight, or we follow a more targeted, please state your questions process, I think remains open for discussion. But I would appreciate the courtesy of being able to wrap our portion this evening so I can go home and go to bed.
No, I agree that I think it's time to wrap this up and move on. So is everyone all right with that? And we'll just have to find some dates to identify when we can continue with this discussion. All right. Well, I do appreciate the SPCC working and trying to get through this. I appreciate Adam and Kevin on working on this, as well as Dave and John, to try and get us to a point where we at least have something to discuss. So thank you. I know there's been a lot of time and effort that has gone into that. All right, so if the two of you want to pack up and head out, you're welcome to. We are going to move on to agenda item 6.1, which is public comment. This is where we have an opportunity to hear from our community members. If you haven't filled out a yellow card yet, please do so and hand it to the Safe Ed officer in the yellow shirt. The reminder, you have 3 minutes to speak. Please address all of your comments to the entire board, not to individual board members, school district employees, or members of the audience. We will not be responding to comments or questions during the meeting. However, someone will follow up if needed. At this point, I have 3 individuals who requested to speak, and I have Joanna Van Raphorst.
I'm short. Anyway, yes, I'm Joanna. Wait a minute. Can I put this down? I can't look up like that. Oh, okay, that's good enough. Okay, Joanna Van Raphorst, and I'm an old timer here. Our kids are 31 and 34, and went to Baldwin, Hart, and Stony Creek. And I liked what this gentleman that was in the back who spoke earlier, I want to give you a little background. I've been involved with the community. I've been PTA board, neighborhood house board, Raya board. Now I'm working with Assistance League, and kind of feel like I'm kind of connected with the community. I want to share two things. One's light. One is, in 2009, Mary Barra came to be the CEO of General Motors, and she changed the employee manual, that 10 pages for the dress code, and she changed it to 2 words, dress appropriately, and it stands today. So I thought that was kind of clever and pertinent to the conversation. The second thing is pretty serious. We have in the United States a young person named Dex Benedict that was, who identified as a non-binary person, and she died in Oklahoma. And it's easy to say, oh, those people. Well, guess what? My sister's child is one of those people. And they have gone through the difficult, not really difficult, just learning who they are, and they are they, and they have come to terms that they are non-binary. They're in a loving relationship. They just got their master's degree, and they're living a rich, full life. But if we do not continue on this DEI journey, we don't want that to happen in our community. And to add to the list of what I do, I'm also a LGBTQ activist. And I think we need to stand up and be very vocal that these people are our community members, and we need to protect them and embrace them and not say anything bad against them ever. Thank you.
Thank you. Next, I have Mary Beth Stewart.
Good evening. I'm Mary Beth Stewart. I am a resident, and I have a 7th grader at Van Hoosen. And this evening, I noticed that when you were discussing restorative practices, behaviors, offenses, how to quantify the egregious offenses, and all of the 7 factors, along with how all of this fit into the Student Code of Conduct, I noticed that you were using 2 terms seemingly interchangeably. And I couldn't help notice that the more you talked about these 2 terms, the more they kept getting used closer and closer together. And I'm not sure you noticed it, but it became very apparent to me, and it was kind of concerning to me. Discipline is about teaching a student how to make a better choice the next time, whereas punishment focuses on using fear. It's about threatening someone, making them afraid, and it's about bullying. And it's threatening. And that's a really big difference. One is about compassion, and one is about scaring our kids. And I'm not sure you noticed it, but we're talking about these 2 concepts for our kids. And my request is to pay attention to the terminology that you're using when you're talking about the Students' Code of Conduct, because that's the conduct that our students are usually getting in trouble for in the first place. Thank you.
Thank you. And last, Clifton Ellis.
Thank you. I appreciate that. I got to tell you, this has been fantastic. This is my first board meeting I've ever come to. And I got to tell you, I'm so happy I took my kids out of your district, all 3 of them, because of the behavior of how you treat Mr. Weaver and Carol Beth. It's disgusting. Even your attorneys sitting over there making little anecdotal comments about them doing their elected job and you supporting it. But I'll tell you, something's missing in your little policy, a religious accommodation. You know what's amazing about that? That's one of the reasons I left your district and took my kids out. Because when you violated my federal rights, right, you rejected the accountability because you didn't have a form or a policy for it, right? That's what you did with those opt-out forms. And when I wrote you, I believe you said, thank you. Thank you for reaching out to the board. You didn't care. So you might want to have a religious accommodation policy in your policy book. It's federal law. You broke my rights. I could still sue you. I might, right? So thank you for that. As far as the rulemaking being given to the superintendent, you need to be specific enough in your policy so that your superintendent is not creating policy in the rules. You can't go around the board and do that. I noticed a few sections on that. Even when the DNR makes a rule for fishing or hunting, it has to go back to the legislature and go through the lawmaking process. You can't get around the duties of the board by giving it to the superintendent. As a taxpayer, I hope you do better, because you lost about 600 kids since COVID. The size of a large elementary school not coming back to you. Fantastic, and you're smiling, so that's good, right? Recording for students. I watched that debate. That was fantastic. You have an attorney who should freaking know better, but said he wasn't very well versed in recording law, right? If you have a right, an individual right, whether you have a bargaining unit or whether you want to make a policy, you cannot take away someone's right. You can't have a bargaining unit come up and say, oh, you can no longer vote, or if you vote, we have to see what you vote. That's just not how it works. If someone has a right, your policy cannot take it away. Creating it, you should know better, puts you at risk, and me as a taxpayer when you get sued. Obscene pornography. Oh, and by the way, you got a camera up there recording everybody while you're telling people they can't do it. Pornography. I look over here on the wall and it says graphic novels. Amazing. You're going to have a policy, but yet that can be in the library while you're giving a great board meeting. Fantastic.
Thank you. We are moving on to additional comments. Agenda item 7.1 is additional comments by members of the Board of Education. Individual board members may use this time to share information about school visits, updates from committees or organizations they're assigned to, or to express their personal opinion. Trustee Blake?
I'm disappointed in this meeting, I have to be honest. I think we worked really hard in our committee. I know I worked really hard. I know that we spent countless hours. We went over words and went back and forth, and I tried so hard to compromise. Trustee Annis worked really hard in these meetings. Trustee Lakui worked really hard in these meetings. She came to these meetings with policies that she wanted to propose, and I didn't like all of them. And she was a little bit of a pain in these meetings, quite frankly, to me, because she argued so vociferously. But you know what? And I say that, with respect. But we came together and we got policy to move forward. And then we bring it here, and then we spend hours going in circles, doing nothing, accomplishing nothing. And it's very easy to tear down the work of other people. It's so easy to be a critic. It's so easy to find fault with everything. It's a lot harder to sit in a meeting for hours upon hours and debate words and bring forth proposals. And one person doesn't do that at all, and then comes here and tears down the work of his colleagues, and that's disappointing to me.
Trustee Weaver?
So let's remind everyone where we started this meeting at. Our board policy was a mess. Basically, couldn't review it, couldn't do anything. Hadn't been reviewed since 2020. So this idea that appointee Blake wants to get his feelings hurt because I'm critical, but as we saw through this the whole time, people were probably just learning about it, just seeing it, going through it. Like, the process actually should have been, we should have been having meetings along the way, working on this as a board, could have had multiple work sessions. President Butel or our past superintendent made the choice to do it this way and allowed it to get so out of shape. Miller Johnson basically put together a huge packet, and as we saw, a lot of the stuff, again, basic questions like why does it exist, what's it there for, weren't asked. So I do not doubt everyone worked hard in the committee, but how hard someone works doesn't mean that therefore you can't, again, either criticize it or work on it, or, because they worked hard. It's about results. We are, again, grown adults that have to get over our feelings and recognize where we are at. These policies, as we go through, we haven't even got to the part that, there's a lot more coming that are just about becoming less transparent, that are about controlling, more about where we saw all about that conversation about the recording. It's about making sure that no one in the district might know that there's a problem. Don't fix the problem. Just make sure anyone doesn't know about it. So that's probably why the board's going to decide to skip over a lot of things, because as we go through this, it's just not good. It's not good policy. Neola's is 100 times better. And with the control that Neola gives us as a board, because I agree with what they said, that some of those are very long, we have the ability to make them shorter if we actually control and decide what we want. But the fundamental thing that we've now seen with this board is there is actually no vision. There's no stated goal in anything that we're trying to accomplish. Again, even think about this packet alone. This scope of work to create this package, nobody knows what it was. It could be from 2020. How much did we pay for this? Like, you start a process, you finish a process, you should know what your budget is. These are real basic things. And yet, again, we have two trustees that have served the whole entire time that this, again, sat and was like no other district. That is Kevin Sutton's word. No other district operated the way we did. And so now to consider, it's a lot of work to fix this. It's not going to happen at one meeting. It's actually going to be a lot of hard work by a lot of people. And if people are going to keep getting their feelings hurt every time someone said they don't like, it's going to make for a long meeting. So, but policy 100% done right is very high level guidelines that can put the premises in place that reestablish trust with our parents and actually protect our teachers. Because again, as Appointee Alspach pointed out, the problems that teachers are dealing with are right now. They are dealing with a lot of nonsense. And again, those policies will protect them when the board and leadership stands up behind them. And when it comes to discipline, whether you want to use discipline, punishment, accountability, whatever word you want to use, it's about having clear standards in which everyone's held to the same standard. Because the biggest thing that came out of this tonight was the clear issue with DEI and around behavior issues. Think about this just flat out. We want to take the data around discipline, and we want to make it more equitable, right? We want to make sure that we have the right discipline for everybody, and based on race or based on this or that. But wait, we can't do that. We have to have inconsistent policy where everyone gets a different thing. That just doesn't make sense. So which one is it? Is it that we want to have equitable outcomes where everyone's held to the same standard? Or do we need to have a policy that is completely messed up so that everyone can get a different response? Because if everyone can get a different response, you can never achieve equity, right? I mean, that's just common sense. You can't get the same outcome where you take discipline data. I see people shaking their head, no, this is hilarious. Okay, discipline data is a number. We have it as a district. We have to report it out. And if you break it down, if you're going to try and control that data, you have to measure it somehow. That means you have to control the outcomes. So you have to start from the basic position of knowing what you are trying to achieve. So it's one or the other. And so you either are actually trying to control that discipline data to make it so that we understand what it is and we're fixing issues, which I 100% think we can do. I think a policy can do that. Or we think we have to have a policy in which no outcome can ever be the same. I mean, that's fundamentally where we're at. You have to decide one of those two things. I 100% believe through actual standards and process, you can actually substantiate the data from discipline and start working on action items that allow us to actually reduce the overall number of disciplines, which then can actually achieve some kind of controllable outcome. But again, we'll see what the board decides to do.
Trustee Lakui?
So first of all, I want to thank Ms. Stewart for bringing up the point between discipline and punishment. Thank you for that reminder, because you're right. Discipline is educational. It's a restorative practice. And, you know, so I appreciate that point. I want to thank everyone on the committee that worked hard on this. I know that there was a lot of work. I was originally on this committee, and I know you guys did a lot, and you had a lot of good discussion, so I really appreciate Trustee Blake, Trustee Lakui, Trustee Ines. I really appreciate the work you put in. My last comment I'd like to make is the community, sorry. The community lost a very strong pillar this last weekend. Our dear friend Grace Drummer passed away. Grace and Rick Drummer have dedicated at least 20, if not 25 years to our community. Their children have long since graduated, and they have gone on and led Boy Scout troops and led the Atom Bots at the high school. The two of them are responsible for at least 100 Eagle Scouts in our community. And the piece that I always admired about the most about Grace is her life was about service and making it possible for students, all types of students, to be able to join the robotics team and to be successful in scouting. It was not about control. It was not about social media. In fact, most of the time when she posted on social media, she posted on Rick's account and would say, "This is Grace." It was not about a personal agenda or circling back to the same control points over and over again. It was about service and rooting in what's best for our students. And that is something that I will always look up to, the contributions of her and Rick to this community. And we have really lost someone who was dedicated to our kids and in an amazing way. So I just wanted to bring that up. Thank you.
I just want to echo Trustee Alsbach's sentiments that we've endured an incredible loss as a community this week with the passing of Grace Drummer. Her and her husband, for anyone who didn't know, have voluntarily run the robotics team at Adams High School for about 25 years. In fact, when my husband and I began running the RHS team 8 years ago, we had no idea what we were doing or getting into, and they were our mentors and have been every step of the way since, really teaching us how to mentor within that program in many ways, but also just modeling to so many students throughout our community what it looks like to live a life of grace, dignity, mutual respect, and service, and lots of service. I am grateful to just have been just this little bitty part of her life, and will often remember all the fun moments we've had at competitions and cheering kids on, and all the lessons she taught me so that I didn't have to make those mistakes myself the first time around when I was new at things with that. And, you know, just to our school community to be conscious, and I know everyone is, but I just feel like the mama bear in me makes me have to say this out loud, that there are lots of students in this district who are deeply touched by this loss and affected. So the more we can all kind of wrap our arms around them and provide support, the better.
Trustee Ennis.
I wasn't aware of her passing, so thank you both for sharing that information. I wanted to thank the Miller-Johnson attorneys who were here this evening, Kevin Sutton and Adam Blakelock. I appreciated them being here for the discussion. We have someone at the board table who really, maybe a couple of people who are real big proponents of Neola using this service, which provides policies. And yes, you can't change the policies provided by Neola, but you'd still, if you were doing your job with fidelity as a board trustee, if you were changing those policies provided to you by a service, you should still do your due diligence and have it reviewed by an attorney to ensure that you are still meeting the letter of the law with any policies that you draft. So what you're essentially doing is you're paying twice. You're paying for a service which provides the policy, and then you're paying for an attorney to confirm any changes that a board proposes. And to me, that's a penny wise and a pound foolish. I mean, we're using an attorney and his firm who provides the policies, provides the consultation, as we saw here this evening, in real time, which I think is extremely beneficial for the job that we do. And I appreciate that. I also want to share that last week I had the opportunity, I was invited by the principal at Hamlin Elementary, Principal Lyons, to attend their Parade of Nations. And they have one of the largest culturally diverse communities at Hamlin. And there were over 40 countries represented by the student body at that school, which is pretty mind-boggling when you think about it. So I really appreciate the opportunity to have gone and to have seen that celebration. It was very joyful, and I appreciated being amongst all the kids. Just a reminder that tomorrow there's no school. I'm sure you were going to say that, Michelle, pardon me, President Patel. But just a reminder to, if you haven't done so already, please go and vote on the RCS non-homestead millage renewal. It's $24.5 million that potentially could impact our district if it is not renewed. And it's important that we get out and vote. Thank you.
All right. A couple people had already mentioned the passing of Grace Drummer. I wanted to acknowledge this loss to our whole community as well. I was lucky enough to know her, and my children both benefited from all the time and energy she and her husband Rick put into both the Adambots and the Boy Scout troop. She set an example of what it means to be a servant leader and to give back to the community. And my condolences go out to the Drummer family and all who are impacted by her passing. I wanted to touch base on our next meeting, which is next Monday, March 4th. It's a special meeting with Ray and Associates, who is our superintendent search firm. And the purpose of this meeting is that we'll be selecting candidates to move on to the interview round. The meeting will be live streamed and recorded. However, for transparency, everyone should know that a portion of it will be in closed session for the discussion of these applicants whose names cannot be known in public. And when we return to open session, we'll be referencing everyone as candidate 1 or candidate 2, et cetera, as names do not legally become public until a candidate has accepted an interview. We will also need to be careful in our discussion to not share details that would identify who the candidate is. We'll be having similar discussions about interview questions, and because we don't want our candidates to know the questions ahead of time, the questions also will be referenced by question 1, question 2. I just wanted to be transparent about what the process will look like, so no one is disappointed if they choose to attend the meeting. Candidates will be announced once they have agreed to an interview. And I think that's all I have for that. So at this point, we'll move on to 7.2, additional comments by members of the administration. Looks like you're the last remaining person.
Okay. Sorry to I won't take up too much time. Is that on? Yes. Mindful of the fact as an educator, longtime educator, that something that I always keep in mind is that students pay far more attention to what we do than what we say. So we can talk to them about how to have civil disagreement, how to be respectful towards one another, et cetera. But if they see us conducting ourselves differently, that falls on deaf ears, or it could, right? And not that I think a lot of students are sitting watching these board meetings. I'm kind of hoping not, to be honest with you. And yet, I think as a governance team, an 8-person governance team, for our students, for our staff members, for our community members, we should be mindful of that, and we should be modeling how to appropriately convey how we feel and how we may disagree with one another without being critical of one another, without finding fault, being harsh. We should be able to continue to be respectful. There's just no reason that that can't happen. And so it's disappointing that we continue to struggle with that. We have upcoming opportunities to be better, and I hope we take advantage of that. We certainly have to find a better way to approach the policy discussion. So I'm a relatively smart person, but I can't tell you sitting here that I have, the solution to it, but I'll certainly give it some more thought. I hope my colleagues here at the board table do as well, and others, and hope we can come to a place where we're able to get through the important work, and it is important work, and with the board, that is one of your primary responsibilities, to establish policy. So we've got to find a way to get through it and do so appropriately. So I hope we give it some thought, and I hope we commit to one another that coming back together and just kind of taking this same approach is counterproductive, and again, we can and should be able to do better. So I think we have an obligation to work on that. The only other thing I'll mention, just real briefly, because it is late, non-homestead operating millage renewal. We've talked about it a lot, but tomorrow is Election Day. A lot of folks I know have voted by absentee ballot or early voting, but tomorrow is actually Election Day. Those who have not voted, the only thing I want to remind people of, just urge you to get out and vote if you haven't yet. It's a very short ballot. You can do so quickly. The financial impact of the district, if it doesn't pass, has already been mentioned. I'll just remind folks that there is no tax increase associated with this. If you're a primary homeowner, not only is there no tax increase, there's no tax at all. This doesn't impact you. If you're a non-homestead property owner or business owner, you own a rental home, whatever the case might be, we have been levying 18 mills, will continue to. This does not increase that in any way, shape, or form. So really critically important to the school district, and I just hope, again, for those folks who haven't taken the time to vote yet, it's not too late, and hope you take advantage of that opportunity. Thank you.
Thank you. As Trustee Annis reminded everyone, tomorrow, February 27th, there is no school. On March 4th, we have our Board of Education special meeting. That's at 6 p.m. and will be at Ruther Middle School. And then on March 11th, we have our regular meeting at 6 p.m., and that is also at Ruther Middle School. At this time, if there's no objection, I will adjourn the meeting at 10:15. Seeing none, we are adjourned at 10:15. Thank you for coming and staying to the end.